In both of them are 86 years old, my lord, and covered by your lordship's judgment, my lord.
And over the slip, mentioning the urgency.
My lord, may I permitted to mention 4 matters for upgradation and
And over the slip.
My lord, may same.
Non-prosecuting fact to be mentioned. Yes.
My lord, may I bring for an upgradation, my lord?
Upgradation motions, please hand over the
Yes,
slip,
ma'am.
indicate the urgency. Yes, call the list.
One.
Lord, this is a matter which was mentioned on the premise that, Lord, the application and the writ petition both can be disposed of.
Yes.
I'll just give you, Lordship, Lord,
But for the petitioner,
for the petition.
who is for the corporation,
Lord, West Bengal Industrial Infrastructure Development Corporation,
who is appearing for them?
they're the respond number 1. And Lord, the WBIDC, Lord, sorry, IFCI, which is respond number 8, they have sold, Lord, leasehold interest in an industrial plot in exercise of surface action. Now, Lord, the writ petition was as to who would execute, Lord, the deed of assignment. Because, Lord, the original lease is for 99 years.
So, core in their absence, how can it be taken up?
Lordship, I am appearing for respondent number 8, IFCI.
You are ready?
Yes, sir. Yes, your lordship.
Yes.
Lord, so, Lord, now the lease was, Lord, granted by WBIIDC. And, Lord, this lease was for 99 years to a company called Bhubaneswari Plastics Limited. That, Lord, obtained, Lord, financial help from IFCI respondent number 8.
You are challenging the order dated 6th of June 2024.
Correct. 6th of June 2024, which was
done by that order.
Cancellation of the allotment. Lord, my sale was conducted by IFCI. Now, Lord, on the basis of a surface action, I got, Lord, the lease. But, Lord, unfortunately, because the lease deed was not executed, no license was granted to me, I could not carry on, Lord, my business. So, Lord, termination was on the basis that I am not utilizing the land. And that's why I came to the court, Lord. There is an order, interim order, which was passed, which is 24th June 2024. Your lordships will find that interim order. It's, if your lordship takes my interim application, which contains, Lord, this order.
Can 1 of 2025?
Can 1. Your lordships may kindly come to page 42.
42, yes.
Lord, the order, Lord, starts from there. And kindly come to around page 49. Kindly, Lord, see the at the top. Accordingly, the operation of the said impugn notice, cancellation allotment dated June 6, 2024 shall be stayed until disposal of the writ petition. Now, Lord, then there was a negotiation. We made a representation. If your lordships kindly sees page 50. This is post, Lord, during the pendency. Our contention was, if your lordship...
Page 50.
Page 50, Lord, our representation. Please come to page 51. Lord, around the middle, the sentence starting with the word, since Messrs. Bhubaneswari Plastics Limited. Around the middle.
Yes, yes.
Since Messrs. Bhubaneswari Plastics Limited has failed to repay its entire loan, IFCI has exercised its security interest for the mortgage property and initiated surface proceedings whereby the property was put to auction and was sold to us. Upon issuing the sale certificate by IFCI, the sale stood concluded and we stepped into the shoes of Bhubaneswari Plastics Limited. Hence, the deed of assignment that now requires to be registered is between WPIITC and us, where IFCI has no role to play and they cannot be a party to the deed of assignment to be executed between us. Hence, we request you to modify the draft deed of assignment by excluding IFCI and share the same with us so that we can start the process of
what happened after this?
Lord, there was a meeting which was held. Your lordships will find that page 53.
21st of February 2025.
Yes.
Between 17th to 21st.
17th and 21st, this meeting took place, where, Lord, the consensus is that it is the WPIIDC who will execute, Lord, the IFCI will execute the deed of assignment, and IIDC will be a confirming party. That is how, my lord, we have reached a consensus.
So who is for IFCI
Your Lordship, I am appearing for IFCI.
and who is for
I
WBI?
appear for WBIDC in this matter, Your Lordship.
So what remains then? If all of you have reached at a consensus, why are you not executing
Only,
that?
my lord, order is required because that 6th June order needs to be set aside, and my lord,
June,
2024, which was stayed by the interim order. My lord, dated
that was cancellation was stayed.
cancellation was stayed. My lord, that should
Can
be,
that be an interim order, Mr. Kaur?
my lord,
What remains to be finally decided? If the cancellation is stayed, that's the ultimate decision.
But only thing is that, my lord, execution of document, unless that takes place, my lord,
But
my
cancellation, if an order of cancellation is challenged, interim order staying that, what's the effect? It's ultimately allowing the writ petition was
That-
allowed on that day
the,
itself.
the problem
Nothing
is,
further remains to be adjudicated.
the problem is, my lord, if this issue remained to be adjudicated, if you look into the prayers of the writ petition as to the execution of the deed of conveyance, my lord, that part of the matter, my lord, still remain. If your lordship looks at the prayers, kindly keep see prayer C.
Execution of the draft deed of assignment.
Yes.
So the draft is ready.
Draft is ready. That page 75, Lord,
Page
kindly.
75 of this writ
Yes.
petition.
Yes. Lord, only
So
dispute-
now, after this consensus, all are agreeable to this or some modification?
no modification. Exactly, this deed is going to be executed, and the assignment will take place. Lord, I tell you, lordship, this draft deed was not accepted by IFCI to start with, because they said that you are a leaseholder under WBIIDC, so you take an assignment from them. WBIIDC said, we have no contractual relationship with you. You get the assignment through IFCI. Now, Lord, after a lot of persuasion, we have been able to.
Mr. Kaur, you said there's a consensus.
Yes.
Is there a consensus in writing?
There is no writing, but Lord, the parties are
Can
before
you
you.
get a consensus in writing? Otherwise,
Parties,
after all, you are representing an authority,
Lord, parties are before your lordships. Your lordship can
or
ascertain.
you know they are representing an
But
authority.
this was forwarded by the West Bengal Industrial Infrastructure Development Corporation.
Page
73.
no, that was prior to that. Thereafter, a meeting was held.
No, now there is no change. Exactly, this document is going to be executed. That was forwarded page
I
7.
follow that. Please kindly come to the CAN page.
Yes.
The meeting, the CAN page 53.
Yes.
Now there was a meeting
Yes.
held between 17 to 21st.
Correct.
All of you uniformly agree that between a meeting was held and there was a consensus reached. There must be some writing, otherwise they are representing the authorities.
Lord, that-
Madam, can't you get something in writing from your authorities?
Your Lordship, we have got a mail. We have got an email that IFCI is ready to sign the agreement.
Where is that?
That's sufficient.
Your Lordship, I have a copy.
Please find mentioning the email. Email, what does it state? Mentioning notice. This is mentioning.
Your Lordship, the body of the email, the topmost part, the body of the email, it says that IFCI is agreeable to sign the assignment date.
Yes. At the top, lordship will kindly see.
At the top is subject.
Sir, then
Body of the email.
just
Sir, agreeable to sign the assignment deed.
Your
yes,
Lordship,
IFCI is agreeable to sign the assignment.
assignment date.
And WBIITC,
Your Lordship, we were not party to the negotiation that they were having.
now are you agreeable to this?
Yes, we are.
Can you
Your
get
Lordship.
something in writing? I'm keeping it
We'll have to
tomorrow or
seek,
day after
we have to
tomorrow.
seek day after tomorrow, Your Lordship, because I
Uh,
need to seek instructions regarding.
The only thing is that 6th June order should go, and Lord, they should execute this document. That will suffice.
Cancellation order has gone, Mr. Kaur.
Lord, cancellation order has been stayed as an interim measure. Lord, mandatory injunctions can be passed, Lord, in a given situation. If that injunction was not passed, Lord, we wouldn't have achieved, Lord, this settlement today.
All right. Now can you agree to some date when you will be executing this?
We'll get it, your lordship, from our friend.
Please agree between yourselves that
Two,
it has
2 weeks.
mentioned that.
Kindly give 2 weeks, my lord. That should be sufficient.
Heard Mr. Call, learned advocate. Be saying that we called him, they did not appear.
We'll work it out. Since it fell from my lord, we'll work it out. We'll work it out.
So if a specific date, on that date, it can be.
Specific date.
Yes,
Much obliged.
yes.
May it please your lordship, my lord, this is the matter, my lord, where your lordship was pleased to pass a direction to serve a copy of the non-appearing respondent.
Serve a copy upon.
Non-appearing respondents, my lord.
Yes, yes, they have
And
received.
Mr. Bhattacharya is not there for the corporation is concerned. My learned friend is appearing private respondent, and the state is also there.
All right.
I think that, my lord, your lordship can take up the matter.
Yes.
Well, although this is a restoration application, I think that, my lord,
What is the main matter?
But today I have been given the impression that they will move the restoration application. My lord. Though I am ready with the matter, I can
Then
assist.
yes,
Yes,
then-
very well.
Yes.
my lord, kindly have a look at the prayer, my lord. At page 17.
Yes.
Read in the nature of mandamus commanding the respondent and each one of them, and the subordinate and the each one of them such and such, the respondent number 1, 2, and the 5, to take appropriate steps for the closing down of the brickyard forthwith.
Yes.
2 is respondent number 2 to cause an enquiry for the restoration of the said area by taking appropriate remedial measures. C is respondent number 5 to start specific criminal case against the private respondent for the illegal running of the establishment and the bringing them such and such.
Yes. Yes, sir.
The
Which
ca-
for the pollution control.
The state is appearing,
Pollution Control Board is the
Is
different.
separate
Different-
independent body. Lord, so far as the allegation is
Mr.
concerned,
Noyan Bihani appears.
yes, generally he
Used
appears
to appear, my lord, long back.
No.
very
Long back.
Long back and subsequently, my lord, all the pollution matters are in the, my lord.
I think, yes, you are right. I think Mr. Arjun Rai Mukherjee appears.
Arjun Rai Mukherjee.
Mr. Arjun Rai, can you inform him, ask him to come because the pollution control authorities have something to say.
Because
And
consent
what
to
is your-
establish
you
and
are from the
consent to.
state.
I'm from the state, my lord, I'm
What is your
submitting,
instruction?
I'm submitting one
Please
report.
inquire from Noyan Bihani and Arjun Rai Mukherjee, I think.
Admittedly, there is no, my lord, consent to establish, my lord, consent to operate. Nothing is there, my
Because they
lord.
have to implement.
My lord,
sir.
my lord.
That is.
my lord, my instruction is
Mr.
that
Arjun Mukherjee.
Yes.
I shall Mr. Arjun Mukherjee to appear.
I think I cannot recollect. Mr. Noyan Bihani used to appear. I think in some matters, Mr. Arjun Rai Mukherjee also appeared. Please inquire from him whether he is appearing. Ask him if he appears. Please ask him.
Then in that event, my lord, kindly allow the restoration today and my lord post the matter in any.
Well,
My lord, okay.
Lord,
Clear.
though my lord, I appear for the private respondent, my lord, I have instruction that I have all the documents. I can
Where is
place
that?
those. Yes, that is the copies of each and every document. my lord.
consent to establish.
Yes,
Consent to
yes,
operate all.
yes, everything. My lord, page 4, internal page 4. Though the documents has been handed over on the last night only, this is a scanned copy.
Kindly see the date.
Internal page 4. This is the consent to establish under section 25 and 26 of the Act.
Four.
Yes, internal
The
page.
period is 26.
The state
1st
that
of
must have
January
any copy, my lord.
2026 to 31/12/2032. This is the consent to establish.
Yes, thereafter, my lord, kindly comes to
Lord, kind-
page, internal page 8.
My
This is
state
the
cannot copy
consent to operate.
Page 8.
Internal page 8, my lord, though it is not marked.
Copy set down.
Devo, sir.
Yes, consent to operate is
Yes,
also there.
yes. Thereafter, my trade license is there. My land details is there. The change of record of rights is also there. My lord, kindly takes up the internal page 2 once.
Kindly see the reply of the RTI, my lord.
But now they have produced the.
Kindly see the
Who has given the reply to RTI?
The competent authority, my lord. Kindly have a look at
Page.
page
my lord.
26 of the
26.
reply. I do not know, my lord, why this reply has been given to.
No, this is not for the house. This is neither here nor there because the authorities, Pollution Control Board has given.
Yes.
Asansol Corporation
then
is
kindly
not
have
the
a look-
authority to issue.
Kindly have a look at 28. West Bengal Pollution Control Board.
28.
This is separate.
This is of on 2025.
This is a separate brickyard, my lord. This is not with.
Separate.
Yes, this is Raja. The RTI
Raja
questions
brick.
is. Yes.
Yes.
You are not.
No. For me, is SSB bricks. I have handed over all those documents. my lord.
This is not a party.
For the private respondent number 9 and 10, I done the brickyards named as SSB bricks words.
The private respondent number 9
and 10, which is the only private respondents in the writ petition. my lord.
My lord, kindly direct them to hand over the documents. I will verify from my.
I will
colleagues.
place YOF and affidavit, my lord.
Uh,
Kindly allow me to file affidavit, my lord. I will place.
Page 31, page 30. Page 31.
Yes.
This is the name of the SSB is also figuring out over there. As per the record kept
The
maintained by
RTA
the
application is not annexed.
no consent to establish and consent to operate and they has been issued in the name of the SSB bricks.
Cling. This is a separate name again.
So this of 1st of September 2025.
Correct, my lord, correct.
This has been issued in January 2026. So now they have the permission. It's subsequent.
My lord, kindly allow me to give hand over all those. My lord,
I will
my lord, I
affidavit.
take instruction and submit.
This is subsequent, and if now they have the permission,
My lord,
cannot
my
be
lord,
stopped.
my lord, my lord.
Please give him a copy tomorrow. I am keeping.
Very well, my lord. Kindly allow me to file
Submit-
affidavit, my lord. Affidavit by way of an affidavit, my lord.
What evidence you want?
My lord, these
For any other
illegible
purpose,
copies, my lord.
for any other
kind of-
purpose you want
no,
to
Willard.
file affidavit.
Very well, my lord.
Affidavit,
I will
please.
hand over.
If you say for other purpose,
Kind
yes,
of
then I will
illegible
consider.
copies is there, my lord, since it has been sent through WhatsApp, my lord. This is a scanned copy, my lord. Quite illegible, so that is the reasons I was praying
You
for.
can read. I think Mr. Dotto
Very
can.
well.
My lord,
Mr.
very.
Dotto, please check up whether you can read or not.
No, my
Willard,
lord, since your
That
lordship.
kindly direct a survey copy to the
I can
state.
read, my lord, I can read.
এটা
My
দেখে
lord.
দিন, ওটা ওনাকে দিন তো।
My lord,
Look at the documents if you can read.
Yes, my lord, very legible,
yes.
very legible.
my lord,
Very clear.
very
No
old.
necessity to file an affidavit.
আপনি রেখে দিন what
My lord, ask them to serve a copy to the state also.
Please serve a copy to the state also.
we do
The আচ্ছা ওখানে একটা লিখে দিন যেখানে
My lord, 3 to 6 and 7 are for the petitioner.
চারটে একই জিনিস। It has been point. ওইখানে লিখে দেবেন WP এর দিন। Five. 3907 of 2026 দেখি আগেরটা দেখি একটা 3903 বলেছে কি? 3903 of 2026 বলেছে তো। Six. WPA 3912 of 2026. Call the next matter. Yes. Okay. WPA 3915. Call the next matter. May I please your lordship? May I please your lordship, my lord, this is my application. I have served upon the respondent, my lord. My lord, this is relating to unauthorized construction, my lord. For the private respondent,
Yes, ma'am,
who is
yes.
for the state?
I don't know.
My lord, I have served with the state. You have served? I have served, my lord. They have received. My lord, the petitioners made representation before the competent authority for removal of the unauthorized construction, my lord. My lord, unauthorized construction on the lands of the PWD as well as the my lord, panchayat. My lord, my ingress and egress totally stopped. As such, my lord, the authority, my lord. Yes, what is your instruction?
But kindly come to page 39, representation.
39, yes.
Yes. And last paragraph.
Yes.
The said Ahadan Sheikh and Tawhidul Mandal having no own land. That is a wrong information. Right? I have the land, I have the registered deed. There is no question of encroachment. Right? This is the right, plot. Right? My plot is 6650, but the petitioner plot is 6651. Kindly see, right?
Your property is
Yes.
which dag? Which dag?
6650 plot number.
There is only 1 decimal of land. My lord. My lord. Private respondent is 6650
50.
and petitioner is
6651. This is the map. Kindly see that.
and what is the PWD? What is the number of the PWD road?
Kindly see, this is clear picture. Right?
My lord, this is Barhampur to Amtala. Barhampur to Amtala road, my lord. West Bengal Highways Act is applicable.
There is
Section
no
10
question
of the
encroachment.
Amtala to Horiarpada.
Amtala to Hariyarpada Mountain. Two-story building, my lord, in front of the house of my
Totally wrong information. My name is
What is the
Tawhidul.
plot number of the PWD? Have you mentioned that?
my lord, there is no plot number.
Why?
My lord,
Plot
my lord,
number.
on the way, my lord, NA's Highway Act, my lord, on the way, my lord, West Bengal Highways Act, there is no plot number, my lord. My lord, this is the vested land to the
There is no plot number.
my lord,
It is maintained by the PWD.
my lord, my lord,
What do you
my
say?
representation is this, my lord, late there we consider the representation, my lord, with notice to the parties, my lord.
Yes.
Grateful.
Item number 9, like, appearing for the petitioner. This is Malay in respect to Malay enforcement of the public land Malay in respect to Malay Krishnapur Khali Malay. This is my affidavit of service Malay. Lordship will kindly take Malay first Malay page 20. Malay, I have annexed the map.
Page
20 Malay. Lordship will kindly see this is Krishnapur New Cut Canal. Malay, I am residing at Malay Dag number
Who is the
4340.
private respondent.
Malay private respondent Malay we have served Malay.
Received.
Yes, all.
When?
Yes, everyone.
When they have received.
একবার দেখি একটু এফিডেভিট সার্ভিসটা দিন now Malad, we have made a complaint Malad on at page 24 Malad, the relevant paragraphs is Malad 25 second paragraph.
Why have you implemented the Bidhannagar Municipal Corporation?
Because it's within jurisdiction. Well, I have respondent number 1 and 2. 2 and 3 is the main Malad, they are Malad, waterways department Malad, chief engineer and
I'm asking you why have you implemented what is the inaction on the part of the Bidhannagar Municipal Corporation and how the mayor is related to this?
representation probably Malad, representation was forwarded Malad, party.
Yes. Yes.
So, Malad, Lordship will kindly take Malad, page 25, Malad, second paragraph. Well, I am the owner of the land measuring about 7 decimals situated at RS Dag number 4340, LR Dag number 8230, Krishnapur Jail, police station, so and so, my lord.
Yes. What is your instruction?
Yes, my
My lord, direct the authority to consider the representation because
lord. Well, let them take, well, this is a public land, this is a khal, this land well, belongs to my lord, irrigation department. Well, this well, I have the information well, for with well, I have received the information. Well, so well, because it's a canal and well, the result is well, they have constructed pakka structure and well, there are serious well, overflows and in this well, rainy season well, will be a severe condition well. And well, I am the adjacent landowner well, the first problem well, I will face. Well, drains will be choked well, and certain things will happen well.
The surveyor, the plan prepared by the surveyor is appointed by you.
This one. Yes, yes,
It is.
it's mine, it's mine, it's mine, it's mine.
When he surveyed this plot and when he prepared this site plan,
লেখা আছে? Malay, he has signed it on my lord. Signature no, my signature is not there.
date নেই তো
There is no date, my lord. There is no date. Well, Lordship will kindly give the direction, Mala. Once, Mala. If it's a public land, Mala, I am here.
But I'm asking you when this surveyor prepared this sketch map, when he prepared this, when he surveyed this. On your own document, there is no encroachment, Mr. Chattopadhyay.
No.
Surveyor has surveyed, he does not indicate the encroachment.
No.
This is not for encroachment.
No, not for encroachment, Mala.
This is
What I am
my
saying
plan.
is that, Mala. Mala,
What purpose he has surveyed?
no,
This is
no, only to show that, my lord, the construction which has been made, my lord, it is over the canal, my lord, that is
That does not show that.
no map. This map is not for encroachment.
My lord, just I am showing the,
Why have you annexed this copy of the map?
just to show the picture, my lord. Why is the canal?
Actual picture as on that date, it does not show. On the basis of this, you do not have any case, Mr. Chattopadhyay.
Well, my representation is there, madam. Lordship, on the basis of the representation, Lordship will kindly take it, madam.
This you have annexed.
Well, I have annexed just to show that madam, there is the existence of canal and nothing else.
This is the topography as on that day, as per the map. Does not show any encroachment.
No,
No.
not for encroachment.
So surveyor will survey leaving those pictures. That's the rules
No.
of survey.
Now, that is the only picture, it's the hand.
Plan of the land.
He's a surveyor, has put the stamp of a surveyor.
This is a site.
Mala, it's a mala.
The manner in which a survey is conducted, Mr. Chattopadhyay.
No, it's not.
This is a site plan.
Mala, Lordship will kindly don't see it, Mala. My Lordship will kindly, Mala, pass an order, Mala, in respect to the representation, Mala. Only on the basis of the
So
representation.
you are not relying upon.
No, I'm not.
Thank you. The
My lord, 10, on behalf of the petitioner, my lord, this is my.
I am for the respondent.
My lord, this is the application under section 10 of West Bengal Highways Act. I have
10.
submitted the representation, page number.
My
16.
lord, I am appearing on behalf of state, my lord.
Yes, what is your instruction?
My lord, no one is available to get to provide me the
My lord,
instruction due to the
instruction.
election process.
Just now I have received just now.
I will request make some
My lord,
prayer.
paragraph 3,
Lords,
my lords.
give the direction to consider the application of the petitioner, my lord. According to law, my lord.
Yes,
Civil.
My lord, page number 16 is my representation, kindly send the authority for consideration.
PWD roads,
Yes, my lord.
private respondents
Yes,
served
all served.
when they received,
Just 2 days after, my lord, after
2 days after or 2 days before.
service that read petition. My lord,
Please check up the date.
my lord, I served 1st April 2026 and they received 4th April 2026.
4th of April.
Yes, sir.
The petitioner of Yes. No application for it. Yes.
That my land, 18 set, this decimals of my land was acquired by the government. That was in 80-81 because of the Subarnarekha bridge. Now, the main thing is that it was not demarcated. Now, I tried to develop my land, this remaining portion of 22 decimals. Now, that was objected to. People are not letting me do it. What I want is that the government, they paid compensation, let them demarcate the land so that I can develop my land. I'm being prevented from developing my land. Your Lordship, will kindly come to the RTI 18, page 18. They say that they have taken, I've got no objection to that. They have paid compensation. Now, what is, means everything can't be, I can't be a undivided co-sharer of the government. They have to demarcate and take it away. And let me develop my own land.
You have received compensation.
I have received everything. Only thing is that they have to demarcate their land separated from mine.
Why do when this land was taken?
81.
What were you doing for so long?
Now, today I have got the money. I want to develop my land. They have to demarcate. Only demarcation, nothing else.
That is one thing. Please, this was acquired under the Act 1 of 1894.
Yes, yes.
Please see Section 4.
Gazette notification is there. I'm not asking.
Section 4, left-hand page. These are the duties they would do at the time of acquisition. They were supposed to do. So you must be knowing that you should have told them.
No.
Yes.
They have done, what they have done is, Your Lordship will kindly see this page.
See Section 4, everything.
Yes.
Demarcate.
Yes, yes.
Boundary.
Otherwise, how will they pay? Otherwise, they can't pay the compensation, but they have not done it.
So if you are agreed at that point of time, you should have approached at that point of time.
No, record is not corrected as yet.
That's a different thing altogether. Correction of records is neither here nor there. If a portion has been acquired, they were, please see Section 4. That was their duty.
Yes, their duty.
So that was done in 81, 82.
But then
were you doing for so long?
Will it remain undemarcated?
It was demarcated.
It was there. They have demarcated. I'll show your Lordship there.
You cannot say that it was undemarcated.
No, I'll show your Lordship.
Section 4.
Your Lordship will kindly come to page 13. Page 13. 13 once. I'm being objected to. That is my thing. I'm not being allowed to develop my land. Page 13. 491.
Because you are overstepping the acquired.
No.
The boundaries at that point of time. That's exactly what is. That's exactly what is Section 4.
Yes, this is what has happened. Page 19.
Page 19.
13. Page 13.
Yes.
491. Your Lordship sees 491. Plot number 4. This one. This thing. Your Lordship sees that there is a.
Can you mark it here? Yes, sir. What is your instruction?
My Lord, I am led by with our Mitra, who is appearing online.
I am appearing for the state.
Yes,
My Lord, I have
what
not
is your
received full instruction.
Why have you not demarcated?
My Lord, that I cannot ascertain whether it was already demarcated or not. And there is another issue. Apart from demarcation, the balance 22 decimal of land, PW is claiming it was acquired. But we didn't find any record at our end at the LA department.
That is the thing. That is the thing. Now, if your Lordship sees page 18, page 14.
Then
nothing has been acquired.
Have you taken instructions that the balance portion has also been acquired?
No, page 14. Your Lordship sees page 14.
My Lord, his petitioner's allegations that PWD is claiming that balance 22 decibel land has been acquired. However, LA Department Jharkhand did not find any record to that extent of acquisition of 22 decimal of land. Actually, it was in 80-81, it was undivided district Midnapur.
And page 18 also. Page 18 also.
18 is not there.
Oh, আমাদের তো হচ্ছে। Page 14 में। এইটা বইটা। And the Gazette notification is at page 15.
The Gazette notification, so Mitra, where the petitioner has said that the balance portion has been acquired by the PWD.
That is the demand
I
of
have not said.
alleged demand of the PWD petitioner has stated. Well, give me 1 minute.
Which page?
I'm saying
I have not said.
it was.
Some people are saying that it belongs to the PWD. I have not said PWD has claimed.
Have you stated that fact?
Yes, yes, yes. Page
At which-
paragraph,
Page 6,
paragraph
para
6.
6.
Paragraph
Page
6.
6, paragraph 6.
Some people are saying that it has been acquired and they are trying to privately.
So please take instructions. If it is also been
My
acquired.
lord, I have
It has not been
spoken to
acquired.
them.
It has not been
The
acquired.
PWD didn't contact me. That's correct. Yesterday, I have spoken to the office of the LA office, ADM office, Jhargram. My lord, can it be directed the ADM to give a hearing concerning the petitioner, LA department, and the PWD at page 17, the representation.
Hearing may
Because
not
the
be
old
necessary.
records has to be.
So the hearing may not be necessary if the entire plot has been acquired. Nothing remains to be demarcated. If a portion has only been acquired, then a question of demarcation arises. Only
Well, Peter, I'll take a detailed report from the ADM LA collector.
the learned advocate appearing for the petition. To enable Mr. Mitra to revert back with necessary instructions. Call the next matter. Sorry. Next Tuesday is off. তাহলে 16th করে দিন 16th. Yes, call the next matter.
But at 16th for report, I believe.
Yes.
My lord.
Order for the state.
Lordship, I am for the petitioner, my lord. My lord, my learned senior is on line, my lord.
Yes.
Lordship, I am for the petitioner. Lordship, though we have served upon the private respondents number 7 and 8, but the difficulty is that only yesterday service has been affected here, Lordship.
The learned advocate appearing. Private.
Friday, your worship, is 16th, I guess.
This Friday. This Friday is 13th.
My lord, can it be taken up next week because all the officers are being requisitioned for the election purposes, your lordship?
You have the instructions.
No, not be of the PL and LRO.
16th is the same thing. Yes.
Very good.
Next.
12. 12 to holo.
12th to holo. Yes.
Lordship 13 and 14. I had participated over their lordships, but they had not opened the online applications, lordships.
Yes.
I had submitted on physical copy.
Yes. Where is Mr. Chakraborty?
In the courtroom. He is on legs.
And Mr.
Yes, Mr. Dey.
My lord, it is dependent on the next matter. That matter.
Yes. Please move the next matter first.
Next
This
matter,
is-
I am not appearing. Mr. Mahato is appearing.
What is next matter is debarment.
Debarment.
Yes, lordships.
Now your lordship has
Mr. Dey, you also made submissions on the debarment on the earlier occasion. Both of you made submissions. Yes,
but I have
sir,
not
make your
taken any instruction, nor I have passed. Hey, tumhe diyeche kaun?
Lordships, in the last occasions, you had asked
He is
for
coming, my
the
lord.
case
He is
laws,
the next court. 15, court 15.
case laws relating to the
Till
blacklisting.
that time, Mr. Dey, you can.
I cannot because I have not taken any instruction on the second matter.
On law point. On law point, not on instructions.
But who will pay? Who will remunerate, not pay?
So if you say that, I can provide.
No. At
That
this,
can be provided. I think in the last, yes, 7.
it's not required, my lord. I have unnecessarily. Hey, ki diyeche, instruction ki diyeche?
Lordships, even though they had supplied the instructions, and the last occasion, my lord, you had asked for the case laws relating to the blacklisting. That is the natural justice should be followed. That is the two case laws we had not handed over, my lord. That is the
Yes,
one Gorkha Security Services case, and one is the Raghunath Thakur.
Please give the references so that Mr. Dey
Yes,
can.
I will supply the copy. And Dada, it is-
One is Ramjan Kalra.
no, 16, para 16 onward. And this one, another case. And irrigations equipment already handed over to your lordships. And Blue Dreams also handed over. And Technoprints also handed over to your lordships. These two case laws are not handed over. And the other case laws already handed over to lordships. Gorkha Security para 16 onwards, lordships.
I am saved now.
No, Mr. Dey, you also remain. Both of you make joint submission.
Full time.
Because both the matters are related. But only one thing, Mr. Dey, why they have not been allowed to submit online?
Even though they had told your
Participate
lordships,
put any?
physical copy they had taken, even they said that the
Your
peace
lordship
auctions
said
also
by-
will supposed
either by
to cancel.
physically or
Not either. Online and as well as
Physical.
physical, both were there.
online.
Because online you
di-
said that's available.
Yes.
Difficulty comes, my lord, for opening after the time is over. That is why now it would become.
But they had said, my lord, they will cancel this auction also. What they said.
That's a different
thing
one.
altogether. If they say so, then I'm saved. Yes, Mr. Mahato.
My lord,
You will cancel this auction also. If that is so, I'm
my
saved.
lord, my lord, in respect of 13, my lord, I am not there. In respect of 13, in respect of 13.
In which tender you are saying that they have
These
said
two auctions, what the table officer said to my client that my
In
instructions
respect of
which RPF, which RFP?
46 and 48. 88.
46 and 48.
in respect of 14 already cancelled,
No.
blacklisted.
46 and 48, they say.
That recently they had floated.
My lord,
Of the
106.
two matter.
48. They are
100
saying 48 that will be cancelled.
48, there is no tender in the brief.
Yes, 48. That is the further new tender.
New tender.
No,
you
no,
said
that
that
is
your officer said
46E.
that will be cancelled.
That is 46E. What you are saying?
No, 48. 48 is, I
48
think,
and
in
48.
this matter. 48 is
7742.
Mr. Mahato's matter.
Yes,
That-
40
that-
Next tender.
I have nothing to.
Because
My lord, in that matter, my lord, already he has been blacklisted and cancelled. Unless there is interference by your lordship, he cannot be permitted. Already he has been blacklisted and cancelled.
Who will argue on the blacklisting?
My lord, I will argue on the blacklist. My lord, particularly, my lord, mm, he had banking upon the 2020.
One thing, Mr. Mahato, in
My lord,
only one thing. 7742 has been blacklisted. No.
Yes.
Blacklisting is under challenge in which matter?
7742.
42.
So your matter.
Yes.
In my matter. If your lordship, my lord, he has banking upon mainly the Technologies Private Limited.
Technoprints.
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 Not technologies.
Technologies.
No,
To 2021. 2021 two Supreme Court cases. 551. তাই কি?
Technoprints.
Technoprints, Mr. Chakravarti
Already handed over.
Let's reliance upon Technoprints, I think.
Technoprints. My lord, here the fact is that, my lord.
Technoprints.
No, not technologies. This case.
Technoprints. That is 2025 SCC online
Yes.
SC.
Yes. And for blacklisting, that is the erosions already handed over, blue dreams handed over, and technoprints.
On blacklisting, he has referred to erosions. That's the parent judgment.
Yes,
Then Murtha Security
then
Service.
he has referred to
my lord,
I
the
think,
distinction in the
dreams.
distinction in the fixed.
He has referred to blue dreams.
Distinction in the facts that here in this case, it has been notified that this clause is there. If you participate, if they are
to the clause ones.
my lord,
to the
yes,
clause ones.
yes. Brief to the. Brief to the. On page 91.
Yes.
In case of bid quoted equal to or exceeding the estimate quantity of earth, entire auction will be cancelled and bid security for the bidders quoting rate equal to and excess to the estimated volume will be forfeited and debarred from participating in e-auction for next 3 years. This is the clause. Knowing fully well, he has submitted. He has not made any protest. He is aware of the thing that if we do this thing, then I will be blacklisted. And he has done this.
Yes.
And specific case is that there is no such prayer, that this clause is in the writ petition also there is no prayer that this clause is ultra vires, this clause is onerous, nothing has been mentioned. And I have cited one decision of 2001 that specific prayer is to be made for granting any relief. And I have consulted the up to latest, the relating to the cancellation and my lord forfeited, Supreme Court did not touch, but in respect of the my lord blacklisting, my lord, I have got the recent decision 2026. Here the blacklisting was set aside after 1.5 years.
Blacklisting was set aside
after 1.5 years. Not but relating to the termination and forfeited untouched. The fact is also difference, not performing the quality work. However, my lord, Hmm? 2025 judgment দিতে বলে পড়েনি তো 2025 judgment করা তো
regard to the decisions which Mr. Chakraborty has cited, do you say anything with regard to those decisions?
my lord, the fact total, my lord, in respect of that, my lord, the factual aspect is totally different. Factual aspect is that, my lord, there are violation of the terms and conditions relating to the performance and others. Here the specific clause is there. Before submission of his tender document,
He was aware.
he was aware. In the other case, my lord, that was not there.
And what do you say to Tej Prakash?
Tej Prakash, my lord,
Here,
Tej Prakash is not applicable because Tej Prakash is, my lord, during the process of selection. Here before,
here also this
no,
corrigendum. This
corrigendum before last date of submission. Before last date of submission.
maybe before last date.
But no.
After
And he submitted, my lord, after 2 months. After submission, if there is any corrigendum, then my lord Tej Prakash would
when
come.
he submitted, please show me the date.
In February he has submitted, and my lord, the last date is
February he has submitted.
yes.
And from you get that date?
Yes. And my lord, yeah,
Submission. This corrigendum was issued when?
on 18th November.
Where is that date? Which page is the date? Third of no. Where is the date?
My lord, on 18th.
Page 87. If I'm not
Page 87.
Page 87. Oh, this is the. No, this is the forwarding copy of 24th of.
No.
I'll just. 87 is the date of tender.
Date of
What is
page
the date
96.
of this corrigendum?
Page 96.
18th of November.
18th of November. And last date of submission is the 19th of November.
18th of September. 18th of
November. And last date of submission is the 19th of November.
No, document started before that. Logic analysis, page 45.
And I have shown, my lord, the tender document. If you
Mr. Chakraborty, when did you submit?
I have, my lord, page 57 once.
My lord, the techno commercial bid started on 29th of October 2025. So when did you submit the document? When did I submit? I'll just. কবে সাবমিট করেছিল? ডেটটা বল। Yes, 27th October. 27th? No, this is.
No. তুমি সাবমিশন করেছো ফেব্রুয়ারিতে। No.
Logic analysis, page 97. Lord, my date of approval is 27th of November 2025. So you submitted on 27th of November.
Before
Maybe
that
one or two days before, 27th of November.
My lord, the corrigendum is on 18th.
That means after 18th.
After 18th.
After corrigendum, you have
After
submitted.
corrigendum. And my lord, page 57 once again, my lord, I am page 57.
Yes, page 57, yes.
My lord, the tender document clearly says before the last date, my lord, before the due date, corrigendum can be made, amended can be made.
Logic analysis, page 45. I'll just show them. 45, yes. Logic analysis, 29th of October is the date of publication of e-auction. The schedule sheet, I'm relying. 29th of page 45. Yes. Logic analysis, 29th of October is the date of publication of e-auction. Logic analysis, last date of sending pre-bid queries was 1st of November. So, whatever objections I have or clarification, I need to participate in the pre-bid meeting. Last date of submission of pre-bid queries was 1st of November. After that, they have altered. Logic analysis, 18th of November, they have issued a corrigendum. With regard to the clauses of corrigendum, I didn't have any opportunity to submit my objection. No, I'm only asking you when did you submit those documents? That is yes, but my humble submission is this corrigendum came into effect after the auction process started. It is not that followed. That is where you wanted to cite Tej Prakash Patel.
Yes, but I am on page 57. Page 57.
Yes.
At any time prior to the bid due date, amendment can be done. And it was done before 19th as per terms of the bid document. Page 57.
5.9.1. Where is the order of debarment? Yes, order of debarment is at page 104. Yes,
No,
104.
104.
And where is that auction evaluation sheet, the financial bid? Auction evaluation sheet is No, no. I was declared H1.
Page 99.
Page 99. 15th of December 2025.
ওটা দেখো একটা তো প্রথমে 1 নম্বরে আছে কত আছে 49,53,590 শান্ত করো
And where is the order of cancellation?
That cancellation is just before that 102. Sorry.
Yes, Mr. Mahato, where is this memo dated 27th of January 2026?
They are trying to supplement by way of providing this document. Copy has been handed over.
Yes.
Darshik, kindly cease. They are trying to supplement the reason.
Oh, this is office order.
Yes. The next one order is the my lord the cancellation.
27th of January, please kindly come to 102. Second paragraph. As per memo number such and such dated.
My lord, the third sheet, my lord.
Order is hereby cancelled. Where is that 27th of January?
My lord, in the
third sheet of the compilation.
If your lordship kindly kindly
the third page.
Yes,
Third page.
third page.
You have given me these two documents, the office order and the.
Office
I
order
think you have not given the correct
no,
copy.
the correct. ये করে দাওনি ঠিক করোনি
নিচে নিচেরটা নিচে
হ্যাঁ নিচেটা স্টিচ করোনি
নিচে নিচে আছে
স্টিচ না না ওটা তো আছে তো স্টিচ করে দাওনি
This come because Mr. Mahato, I think, has concluded. It does not have much to say.
my lord
Mr. Mahathir, concluding matter, then we have already submitted the.
No, tender is subject to this.
Yes. It is
So, I have some questions to put it to you in the other matter.
স্টিচ করে দেয়নি কেন আছে তো চার কপি ছিল তো
Darshik, kindly cease. Lord, they have relied on another documents dated 24th of December.
Where is that 24th of December 2025,
They
Mr.
have,
Mahato?
they have not produced.
Which you have referred to in the memo dated 27th of January 2026.
my lord এটা তো দেয়নি তো কিন্তু কত সময় করে চিফ ইঞ্জিনিয়ার my lord perhaps that is the এটা তো আমার হাতে নেই এখানে এতে মেমোটা রেফার করেছে মনে হচ্ছে এটা ফরওয়ার্ড করেছিল এটা অ্যাপ্রুভালের জন্য কন্টেন্ট নেওয়ার জন্য my lord that is not
Where is
the
the memo dated 24th of December 2025,
my lord
on which this 27th of January 2026 was
yes
issued?
my lord this is perhaps the consent my lord I have not my lord asked for that memo
So, Mahato, this is the document on which you have based your 27th of January
27th of January,
forms the basis of the cancellation order.
my lord, this is the, my lord, the approval of the, my lord, the
So
secretary.
where is the parent document? The decision taken. Approval is one thing. The initial decision is the thing
My lord,
which has
that
to
is
be
that
tested.
my lord, that is not the prayer for my lord, the consent.
Therefore,
Consent of the
yes, on
department.
the basis of what?
On the basis, my lord, on the basis
The
of the
basic document 24th of December 2025.
এক্ষুনি ফোন করো তো এক্ষুনি ফোন করো তো 24th ডিসেম্বর একটা মোবাইলে পাঠিয়ে দিই
Yes, please get that document.
Yes.
Anything more, Mr. Mahato?
My lord, nothing more, my lord.
All right. Yes, Mr. De. The other matter.
Not only with regard to, my lord, the judgment, my lord, cited by my learned senior, my lord. Lordship kindly sees, my lord, the judgment cited.
How much time we will take? So that Mr. De, I think, was going out for some purpose.
No, no, my lord.
How much time?
My lord, this
5 minutes?
yes.
Yes, that will.
Lordship kindly sees, my lord, the judgment itself, my lord, says that blacklisting is not automatic. Paragraph 18. My lord, may I just read? The contractual conditions governing termination on the one hand and those that relate to blacklisting on the other are distinct and will be exercised independently. Has your lordship got, my lord? Paragraph 18. A decision of blacklisting is not automatic. My lord, they are trying to harp on, my lord, the blacklisting is automatic. It will be an empty formality. My lord, the Honorable Supreme Court says it is not automatic. And certainly not a logical consequence of a decision of termination. Even after the department decides to terminate the contract, there is still a choice of exercising the power of blacklisting. These decisions operate in two dimensions, past and subsisting for termination and future for blacklisting. In other words, an order of blacklisting transcends the existing contract and debars the contractor from contract.
Judgments are precedents on the facts of those judgments.
Facts are different.
Please kindly come to page 10 of that judgment.
Yes.
10.5.
10.5. Yes, my lord, 10.5. Before blacklisting a contractor of a particular category, it will be necessary to issue a show cause notice.
So that terms of the contract
Agreed.
prescribes
My lord, agreed.
show cause notice
Here the
has to be
case is
issued.
different.
On that basis,
On that basis.
this decision is on that
My
line.
lord, case is different. My lord, then it should not be
precedent
relied on
will
also.
be tested on the facts
My
of
lord,
that
then it
case.
should not be relied on also. Because, my lord, the case, my lord, the facts of the case is different. It can be distinguished in that sense also. Now, lordship kindly considers.
So, this also does not support your case because
No.
here it says show cause notice.
My lord, I completely agree with your lordship. My lord, only two decisions relied on. My lord, I will be relying on those two decisions. Lordship kindly sees, my lord, the erosion judgment has been relied on paragraph 19.
From the first judgment, Mr. Chakraborty was on a fact where the contract did not contain a clause
Yes.
for blacklisting. Subject to correction by you. Subject to correction by you. Erosion's judgment is not on a contract which contains. You can check up that. I can come within 5 minutes.
My lord.
Time.
I have got the memo, my lord. My lord, this is, my lord, only for taking consent relating to the, my lord.
Can you download it?
My lord, yes,
Please share this with to Mr. Chakraborty.
yes, sir, I am sharing. Only this, my lord. The outcome is 27th. I am sharing now. Yes,
Sir, take out copies, please give it to.
yes, yes.
You can share a soft copy to Mr. Chakraborty. So
Yes,
that he
yes,
can
I am
read
here.
and-
I am here.
Yes, Mr. Chakraborty.
Lordship kindly sees, my lord, the erosion judgment. Your lordship was, my lord, telling. Lord.
Illusions judgment subject to correction is not.
No, my lord, it is.
Condition
My
for
lord, I have.
blacklisting in the contract.
My lord, I have gone through, my lord. My lord, it is not apparent, my lord, whether there was any clause for blacklisting or not. My lord, be that as it may, my lord, there was an inquiry conducted and it was
That is
blacklisted.
all right,
Yes.
but
But my lord, I didn't find, my lord, anything that the contract clause didn't, my lord, contain any blacklisting clause or not. My lord, that is not, my lord, here. My lord, I have, my lord, gone through. Lordship kindly sees, my lord, the judgment, my lord, the basic principles of natural justice, my lord, I'll be relying on this, my lord, 2021 volume 2 SCC, page 551. As my learned senior has, my lord, relied on, my lord, that judgment, my lord, it has taken care of. My lord, this is UMC Technologies Private Limited versus Food Corporation of India. Lordship kindly sees paragraph 13. Paragraph 13, Lordship kindly considers, my lord. May I just read, my lord?
25 টা বলে দেবে তাহলে আর আমাকে
At the
check করতে
outset,
হবে না।
Paragraph 13.
13.
Sorry, I'm looking at 14. Yes.
My lord, may I just read, my lord? At the outset, it must be noted that it is the first principle of civilized jurisprudence that a person against whom any action is sought to be taken or whose right or interest are being affected should be given a reasonable opportunity to defend himself. The basic principle of natural justice is that before adjudication starts, the authority concerned should give to the affected party a notice of the case against him so that he can defend himself. Such notice should be adequate and the grounds necessitating action and the penalty stroke action proposed should be mentioned specifically and unambiguously. An order traveling beyond the bounds of notice is impermissible and without jurisdiction to that extent. This court in Nasir Ahmed versus Custodian General Evacuee Property has held that it is essential for the notice to specify the particular grounds on the basis of which an action is proposed to be taken so as to enable the noticee to answer the case against him. If these conditions are not satisfied, the person cannot be said to have been granted any reasonable opportunity of being heard. My lord, here Lordship kindly considers, my lord, even if there is no clause that a prior notice has to be given, then also, my lord, any action, my lord, which has civil consequences, my lord, has to be, my lord, given a notice. Prior notice is a mandatory, my lord, one, my lord, the Supreme Court is saying. Now, Lordship kindly considers paragraph 14. Specifically in the context of blacklisting of a person or an entity by the state or a state corporation, the requirement of a valid, particularized, and unambiguous so-called notice is particularly crucial due to the severe consequences of blacklisting and the
So straight away
stigmatization.
come to paragraph 19. All those are consideration of those judgments.
Yes.
What should be the show cause notice? Whether the decision can travel beyond the show cause notice on
Yes,
those
yes.
points.
All
those
all
paragraphs.
these were 19 and
Paragraph
25.
19 may help you.
Lord, paragraph 19, Lord. In light of the above decisions, it is clear that a prior show cause notice granting a reasonable opportunity of being heard is an essential element of all administrative decision making, and particularly so in decisions pertaining to blacklisting, which entail grave consequences for the entity being blacklisted. In these cases, furnishing of a valid show cause notice is critical, and a failure to do so would be fatal to any order of blacklisting pursuant thereto.
Yes, anything more, Mr. Chakraborty?
No, my lord.
20.
Yes.
And my lord, so
And
far
Malaka,
as
kindly go to the 25 also. Paragraph 25 in this is this.
25.
Yes. Paragraph 25. The notice was not clear relating to the blacklisting.
That is, my lord, a settled law, my lord. If the
Yes,
show cause notice term is ambiguous,
ambiguous, my lord. But
here
here in
no
this
show cause
Decision cannot travel beyond the show cause.
No,
Those
my
are,
lord.
well accepted
My lord.
positions of law.
My lord, only one thing, my lord. Lordship kindly considers, my lord, the reasons, my lord, cited there. My lord, I have not gone through. I had no occasion, my lord, to go through, my lord, that reasons, my lord,
The same as in the other matter.
as in the other. My lord, be that as it may, Lordship kindly
I
considers.
have also directed you to share the.
I have
Lord,
already
Lordship
said
kindly considers who has taken the decision. It was an adjudication process
That
through
you have
which,
said
my
that
lord,
it
the
has
same argument, my lord.
Yes.
Now, my lord, they are trying to supplement, my lord, the reasons which are not, my lord, acceptable, my lord, in view of the yes.
You have cited everything. Yes. Anything more?
No, my lord.
Yes, Mr. De.
I have made my submission
ঠিক আছে, ওটা তো একই ব্যাপার।
because of the department.
Cause of the debarment. No, there are two things. Cause of the debarment cannot be a ground for cancellation of a tender which was floated. So what's the ground of cancellation of the tender?
That I'm sure. That I'm sure.
Debarment may be a ground not to allow Mr. Chakraborty to participate in the
Yes,
future tender.
That I'm sure.
But what is the ground of cancellation as in?
Kindly come to my lord, page 28.
That is 7741.
Yes.
7741.
41, yes. Page?
Page 28.
Only one clarification in this matter that clause, debarment clause was
Also, my lord,
corrigendum.
corrigendum.
I'm not on that.
But here it's not the
It's
debarment.
not
is
an
not
issue.
Debarment is not an issue.
Page?
Page 28. Lordship will find selection of contractor for the work.
Yes.
Dredging, desilting, removal of riverbed material from such and such place to such and such for a length of 14.40 kilometer. Lordship got it. Now, my lord, after it was floated, it was found that the length would be lesser.
When?
That is why the second.
When it was found, Mr. De?
Then affidavit is required. If my lord, that is the detailed one.
All right.
Then kindly come to page 102.
102.
রিজনসটা কত যেটা দেখিয়েছিল
Yes. No, show me the decision of cancellation first before proceeding to 102.
Cancellation at 101. Administrative reason.
এইটাতে কি রিপোর্ট দিয়েছো পুরো রিপোর্ট জমা দিয়েছো
না
Is it sufficient? Reasons for cancellation, Mr.
Administrative reason I have, it is apparent from the face of the record at page 28 and page 100.
Page 28, it's not apparent. Page 28.
No, 102.
This was the length.
Now
And
length has been
101 is the decision.
And 10.
Mr. De, those propositions, a highest bidder do not have a right to get a tender or to be entered into a contract. An authority can even discard the highest bidder and can enter into, not cancel, can enter into a contract with any other person. But
here, my lord,
for that, the authorities are supposed to assign reasons.
Yes. Administrative reason is apparent from the second tender.
No, cannot be.
Because
it is to be tested. The first tender, you have to show the reasons are there in that, not the second tender. That's the subsequent. What action you have taken subsequently, that cannot form the basis, or you cannot supplement the reasons of the first tender. Second is, Mr. De, another question to you is, you have the right to accept or reject any bid. Any tender inviting authority or auction inviting authority has the right. That right is inbuilt in a bid document. Everywhere you will find that there is one clause. Authority has the right
to cancel at any moment.
Now, can it be, and state or its instrumentality can it cancel a tender or reject a bid according to his whims?
No, no, absolutely.
So
Absolutely.
some reasons are to be assigned. Show me the reasons for cancellation of this bid.
Reasons, my lord, then I have said, my lord, if your lordship so want, my lord, affidavit is required. Then one, this is one. Secondly, it is apparent from the record.
Can you supplement, Mr. Dave?
No, it's not supplementing.
Yes. Show me from the documents.
Documents, I am showing it.
Show me from these documents of this tender, not the second tender.
No,
not because, Mr. They show me any decision of this in this tender that that forms the basis from the materials on record.
Just give me a second, my lord. দেখো তো রিপোর্টে কোথাও আছে লেখা প্যারা 6.6 পেজ 44 পেজ 44 না বিরাট
On 2nd of February 2026, how many auctions you have cancelled, Mr. Day? On 2nd of February 2026, how many auctions floated by you has been cancelled by you?
Well, those are not
series. I can produce series.
I'm dealing with all the matters.
Those are,
that is why I'm asking.
Those are not those are not the allegation in the writ petition.
No, it is
I'm
allegation.
asking you, not the allegation.
I'm
asking you.
Then I have to take instruction on that. This is one. Then, my lord.
Because everything is stereotyped.
No,
the memo, yes, the memo which Mr. Mahato has today forwarded, that is why I wanted to see that. Same stereotype later in other matters also.
But I am not in those matters. Let us, my lord, confine to this matter, my lord.
Yes.
At 6.9 at page 45.
Page 45.
Yes.
6.9 is the tender clause.
Yes.
Page
45.
6. Yes, rejection of bids.
Yes.
Yes.
Notwithstanding anything contained in the tender document, such and such, reserves the right to reject any bid and or annul the tender process and reject all bids at any time without any liability and or any obligation for the acceptance, rejection or annulment or without assigning any reason thereof. Next is the such and such engineer reserves the right not to proceed with the tender process at any time without notice or liability and to reject any bid without assigning any reason. Next is, my lord, without prejudice to the generality of the foregoing, superintending engineer reserves the right to reject any bid on any criteria specified in this tender document, including without limitation.
This, I think, yes, accepted. So within time, not submitted, not documents. You need not travel that 6.9.3.
So they are now rejected my bid.
I started with the same that most of the documents, like this, you finding that clause, the authority reserves the right,
and it has been rejected on administrative ground.
You have said without assigning.
Ground is evident from the second bid. Second proposal.
Cannot test. Can it be tested on the ground of second proposal, Mr. Dey?
Yes, I am telling, because if it is reduced, if it is other
subsequent action, can you justify the first cancellation? Because that was not under contemplation as on that date.
True.
So,
no.
So that could not have been the reason.
Everybody has, my lord, submitted their bid on the basis of the length. Everybody would suffer, because if the length is reduced, the rates would be at a lower rate.
All right. So there are two aspects of the matter. There are two stages of this auction.
No rate.
So basically the project is same, only a reduction.
Yes, only reduction.
only a reduction, only an estimated volume, floor volume has changed.
That's right.
There is no other change.
There is no other change.
So effectively more or less identical with some minor variations.
It's not minor, it's a
Minor,
14.40 and 13.80.4 it comes to
kilometers. So minor according to the length. What is the percentage?
About 1 kilometer.
What percentage I am saying? On percentage basis?
14%.
On percentage basis, how much?
Then I am to open the
not even 10%. It will be less than 10%.
Yes, less than.
So 90% of the work is same. That is why I use the expression minor with the percentage calculation.
But then
no. Yes.
We would not be same. Money would be the.
There are two aspects of the matter. You have started a tender process. As Mr. Mahato was saying, I have a right to change this corrigendum, issue this corrigendum at any point of time. So whether the participants could not have been allowed to give a fresh bid, financial bid, because technical bid, there will be no dispute. Only the financial bid with regard to this change of these kilometers. Could you not invited those tenders to resubmit their issuing a corrigendum if they were agreeable? Did you undertake that exercise?
Now, after opening, everybody knows the rates.
No, after
difficulty would be there. I am telling you.
The fresh tender, everybody will also be knowing.
No, maybe, but
everybody knows.
No, but after the money is known, the package is known that one A has given such and such, B has given, C has given such and such. If that table bid is allowed, it's called table bid. There will be difficulty.
It's not table bid, it's online bid.
Online, but after
parties are the same thing will happen in the next tender, because everybody knows the earlier.
Yes,
everybody knows.
Now it is open.
So what you are saying that everybody knows, next tender also everybody knows.
But what
was the bid?
What is the effect? If the second tender comes,
yes.
What is the effect? Everybody will participate again. There is no difficulty.
That is why it's not a general thing, because
no. If the terms and conditions are not varied, everybody will get a chance to participate. Your lordship has allowed him. Your lordship has allowed him.
That's allowed him to participate since this matter is pending.
No, because of the debarment, he was not.
Yes.
Now he has participated.
Now he has participated, but he will not accept him, provided final decision on this debarment comes.
Yes, naturally.
So that's one thing, but that is one way of looking at it. Second thing is whether this clause.
What page? I was thinking, let your lordship complete first. What are the clause?
This rejection of bid 6.9, what we are saying, it uses the expression without assigning any reasons thereof. So, do you mean to say, yes?
No reason is required.
Yes.
Reason is there apparent.
What? Administrative reasons?
No, administrative he has given because it has been reduced.
Only administrative reasons, nothing.
Yes.
Only administrative reasons.
And it is apparent that the distance has, the kilometer has reduced.
That could not have been, on that date, this reason was not there. Please,
True,
what is troubling me is, Mr. Please see the page 101.
101.
Yes, this is the order of cancellation.
Yes. It is only
on 3rd of February 2026. That is why I mentioned this date. On that date, how many tenders you have cancelled. And please see the next proposal. When it comes
102.
Page 102.
Next proposal.
Yes. So it comes when?
It come on the same day?
No.
2nd of March.
On 2nd of March 2026.
Yes, because it was found.
So this cannot be a ground, because this was not available as on 3rd of February.
No.
This proposal.
Document was not there.
Yes.
Document must be coming after it was verified that the reduction of kilometer is there. The moment reduction of kilometer was ascertained, cancellation was made.
In how many matters this mistake was done by your authority?
I don't know, my lord. I have no instruction on that.
2 matters I have got. 2 matters there is a mistake. Both the matters. 2 matters I have got, not in this, the earlier round. Same, I am telling you.
The same thing, these bidders participated in one debarment, second earlier where he succeeded cancelled, and with this minor changes, reduction of that kilometers with the floor volume. That is why I'm asking. That is why I'm asking you, your authority, what is they are doing after prior to issuing that auction, they are saying something, and after issuing this auction, after that,
after the bid is opened, coming with a plea that my lord is possibly wanting to say that the reduction of kilometer is there.
And you
so
know, in that matter, what it happened? Report says one thing, next bid says another thing.
Next bid.
Different. Same thing, I'm saying. Stereotyped, everything. All matters.
Lord, I am not on those matters, Lord. It's very difficult to answer this query. But then this is apparent.
Officers know that. You may not be knowing.
But this is apparent. After the distance was ascertained that it is lesser.
In every matter, there's a mistake.
Same thing. Same thing.
Why should the parties suffer for your mistake?
No, party would not be suffering.
So how we will protect those parties? They should not be penalized for your own action.
No, absolutely.
Can you treat them as eligible as on that date? You have to treat them as eligible as on that date because as on that date they were eligible. On that date they were eligible. Only for your mistake you have cancelled.
Yes.
It's not for their fault. So eligibility has to be tested as on that date. Eligibility has to be tested on that date.
On
you
the
can
date?
Change. Yes. As on the date of the earlier auction.
Then also he goes.
No.
Higher rate.
No.
Higher rate.
No. Of the second tender, not the first one.
No, in the first tender.
First tender, as on that date, he was eligible. What are you saying? The debarment comes after that.
Why?
Same thing. It's in the mind.
But then
so eligibility as on that date, in order to, that is what I am getting an impression. Are you trying to protect someone?
No.
Or you are trying to side with someone?
At least I am not.
I am not telling you.
My client.
After
but I find.
Don't take anything that I am not saying anything against you.
I am with open mind. I am telling you, Lordship. I find
everything is the same thing.
But
how someone you are doing this.
But I find in this case, personally speaking, that there is change. Change is not
but not reflected in the order of cancellation.
No, it's not reflected.
That you are accepting.
That I am accepting.
So that could not have been
the
reasons for cancellation as on that date. Could not have been the reasons for cancellation because you cannot supplement that by any other document.
No, records have to be produced if your lordship so wants.
You have to speak out in the order which is under challenge. MS Gill.
MS Gill.
Yes. You cannot supplement anything more than that.
Supplement or supplement.
Only has to be tested. You cannot supplement by saying yes. Those are in my file recording. Those are in my file notings. Cannot be to at that. That's the decision also he has cited in this matter.
So power to cancel is there. Now the reason assigned is administrative.
Question is power to debar is also there. Power to cancel is also there. Of power by such authority are different things.
Must be.
So you have to exercise your power, being a state and instrumentality. So you have to exercise, even if you have a discretion, those discretions have to be exercised.
Must be reasonable. Must be.
Show me the reasonableness.
Reasonableness I have shown.
From the documents, not from the subsequent tender. That's not reflected
subsequent
here.
Tender, yes, it is reflected.
That's not reflected in this document, Mr. Dev, because he has
in the cancellation, it is not there, of course.
Cancellation is also not there. That is what I am saying. First, debarment also is one thing. What you are trying to say, it's automatic. My question to you is.
No, debarment, my lord, Mr. I'm not jumping on that now.
Mr. You have made your submissions on the other day also on.
No, it was apparent. I said it was apparent.
Apparent, automatic, yes, from the clause itself. My question to you is, it's a penal consequence.
Yes.
So, what's the foundation of an imposition of penalty.
If it is apparent that you have quoted
Penalty. Before imposition, what's the foundation? Mens rea.
Foundation is apparent. I have
Mens
said.
rea is an important element in penalty.
Mens rea is here. He wanted to upset the tender.
When there is
He
a
wanted
mens rea,
to upset the tender.
Sir, when there's a mens rea, so whether there was an intention, that is to be tested.
My lord, he knew that if the higher rate is given, if the higher rate is given,
Yes. He knew the terms and conditions.
Specifies.
After participating, he also cannot challenge that. Accepted. So no dispute on that. The question is, you have the power, but how you will exercise that power? If you want to impose a penalty, you have a power to impose a penalty. There's a distinction. You have a power to impose a penalty, but for the purpose of imposition, can penalty be imposed straight away?
My answer would be, in a writ court, is a court of document, record. If it is apparent from the record, the court cannot be a silent spectator. If you wanted to upset the entire tender by putting an amount which is known to you that it is debarred, it is not
I
committed.
wanted this from you, Mr. Dev. So if that was his intention, so intention mens rea comes. So now let us not, with regard to this matter, let us take an hypothetical case. Now, it's different from this. I'm not saying that, otherwise Mr. Chakraborty might jump up and say, this is my case. It's not the case of, let us assume that you are trying to do something, at least I am saying, I do not know for you, through online mode. You do some mistake in putting some figures.
Correction provision is there.
Do some put some figures by mistake, which is in violation of this clause.
No,
but I tell you, there are two things. It might be intentional. It might not be intentional.
No, correction provision is there.
Where is that?
Kindly come.
Please show me. After financial bid is submitted,
Just
where is that provision for correction?
Just give me a second.
Provision.
Just give me a second. I was just looking at. Kindly come to page 44, 6.6. Possibly answer is there.
No.
No, this is prior to
techno-commercial bid, not financial bid.
Financial bid, there is no.
Bidder may modify, substitute, or withdraw its
techno-commercial bid, there is a difference. You can modify, not financial bid.
Financial provision.
Cannot, Mr. Dey. Financial bid, you cannot modify. It's the end of the matter. Then these are disastrous consequences. You know the highest bidder, you modify that.
No, highest bidder, nobody can open it.
You cannot correct financial bid. It's techno-commercial bid, it's only documentary to consider the eligibility. Subject to correction by you.
It's techno-commercial.
Yes. Not the financial bid. Now, let us, so by mistake, I was on that example. By mistake, I put some figure.
Consequence will follow, you have to suffer.
There are two things. Maybe I intentionally did that, or maybe by mistake. If you ask me to put that, I will definitely
say that it is by mistake.
So if it is a mistake, whether it will penal consequences can follow automatically.
It is nobody's case in the present case. In the present case, it is nobody's case.
Why I said that Mr. Chakraborty will jump up and say
he cannot.
No, hypothetical case.
Hypothetical case.
You have to test the provision, taking those extreme.
My lord, I tell you, lordship.
If there is so intention, as you have said, intention is a
yes, intention is apparent.
If intention is there, is it not necessary that a party should be afforded an opportunity to represent his case. Whether you can say, yes, that would be your show cause notice. Yes, you intentionally did this thing for which these are the consequences as per the tender document. He has to make a
But
representation. You may or may not accept that.
I tell your lordship, how the bids are or financial bid is placed. Everybody types it, verifies it once, twice, thrice, then enters. There is no chance of mistake.
A mistake, Mr.
No.
Difficult.
Financial bid, there is no chance of mistake. I tell your lordship.
Mistake might occur in giving those. In very many matters,
My lord,
because, not only in online, Mr. They.
No, online, my lord, it is checked. Nobody will enter. Nobody will push the button enter without verifying twice, thrice, 4 times, 5 times.
No chance. It's within seconds. 2-3 seconds, these bids are being put.
But one must verify and enter.
They within. Let us suppose you have given a bid. I give a bid. The next bid. So it's within 2-3 seconds.
In both the cases, it is nobody's case that by mistake it was there.
No, it is a case.
I'm not saying that. Is why I started by saying that Mr. Chakraborty will jump up and not on this matter. I'm not on this matter. I started by saying I'm taking a hypothetical.
Let a case come, we will argue. I will argue. But this is a case. This is a case.
My endeavor is because Mr. Chakraborty's argument is show cause is to precede this. Your argument is no, it's automatic in view of the terms. These are the two arguments on these terms, not on facts.
If it is
apparent, he has made a mistake, he has not made a mistake.
It's not nobody's case.
That's a different thing altogether. Whether he intentionally did or intentionally did not do that. So only thing is that if some act results in penal consequences, whether before punishing, that's the
Murder, audio alter and pattern or principle of natural justice is required in a case where it is not apparent or explicit from the document itself.
So according to you, on the basis of this clause, no opportunity of hearing.
No, not only that. If the document speaks a volume, no opportunity is required. And if it is before the court of law will accept the.
That's one part. Second thing, quoting a bid over and above that estimated volume has 3 consequences. One is cancellation. Second is forfeiting the bid security. Third is debarment.
It's not or. It's not.
No, I'm not saying or. Now I'm asking you is whether you have a discretion to impose either of them or you have no option left. You have to impose all in all cases.
I have right.
Each and every cases.
I have right to. My lord, take all the 3 points and penalize as provided when there is right.
Right is there.
Yes.
I'm not disputing that you do not have a right. My question to you is whether you have a discretion left with you. Power is there. Whether you have a discretion left with you to impose either of them or you do not have any choice, you have to impose all of them.
The clause
That's
says,
my question.
Clause says, and my lord, I will be saying that he has a right to do.
Right, it's not disputed. You have a right. Exercising that power. While exercising that power, whether any discretion is left with you or you are left with no discretion, you have to impose all.
My lord, if there will be chance of.
Please look at the clause.
No, I am answering.
You can read the clause once.
If discretion is allowed.
You can read the clause once, Mr. Day. I am telling you for that.
Corrigendum
49.
Page 49.
No, sorry. Not 49.
So the corrigendum.
Corrigendum এটাই আছে?
No, এটা বোধহয় in the corrigendum.
Yes, page 76.
Page
76.
Of the matter which is taken now.
clause 21.
Yes.
Yes, yes. New clause was inserted. If one court explains that he had a discretion to punish either, not both, court expresses the view or comes out. No, I am answering. I am answering. Then it would be given an open hand to discriminate case to case to the department. In A case, one would be only forfeiting. In B case, you are punished for 1 year, 2 year, 3. This should not be. That is why it is mandatory.
If the violation was unintentional, let us take a hypothetical case.
It is not. I have said it is apparent.
Yes, apparent conditions are apparent. I am giving you a case. The violation was unintentional.
He will withdraw from the tender.
Cannot withdraw.
I cannot.
Cannot withdraw.
There is
It
no
will then-
escape route.
He will be debarred. It's the next clause. The next clause
There is no exit route.
for next 1 year. So there are the two consequences.
Yes.
Even then he will face that for
Well,
he will face that debarment.
hypothetical cases, I have
He
answered.
cannot also back out.
I have answered to that. A persons who are dealing with the tender matters or gives tender, he verifies the amount he is offering because it will go from his own pocket. Once, twice, thrice, then he enters. It cannot be, under a hypothetical question, it cannot be. Mistake, it cannot be, there cannot be a mistake. These are my suggestions.
And on the decisions you want to submit?
And nothing.
Decisions
Excepting
which
a
are
report has come, there is a mistake.
report.
There is a mistake.
What a report?
Yes.
For what?
About your lordship wanted that to allow him participate or not.
Yes. What is your report?
My lord, he has said in case stated debarment remains effective, the petitioner is not allowed to participate in any e-tender process. Otherwise, the petitioner is allowed to participate in it.
Anything, any report has come with regard to the reasons for cancellation?
No, it was not the query from the court also on the other day. And there is a mistake, that is why I am not giving. 14.40 is written, it would be 13 point something.
13 point?
13.8. 20. 13.80.
80. No, that's 13.80 is the
second tender.
Yes.
That has printing mistake is there.
So what it has been written there?
Length is 14.40.
See, the
No.
authority is also.
No, mistake is there. I am not submitting that is why.
So you can make mistakes, they cannot. You can make mistakes. Mr. They, it's the prerogative of the authorities. They can make mistakes, they can cancel. But the
In my pocket,
but the bidder cannot.
Yes, bidder cannot because
Bidder cannot make any mistakes.
the money goes from the coffer, goes from the pocket of
And
the
the money for this second tender, there's no financial involvement on your part, Mr. They.
Yes, I will
Who
be
is
getting.
responsible, from whom he will recover for this mistake? Have you identified who is responsible for this mistake? He has to make good that deficiency.
If lower bid comes.
No. You have cancelled the earlier one. Again floated. What's the financial implication of the earlier and
financial?
So that's because of the mistake of your That's because of a mistake of your authority.
No, my lord, a financial question will come after the bid
No,
is,
no, with
second
regard
bid
to
is
floating
open.
of tender, there's no financial implication on your part. Department, this cancelling,
Very less.
this managing, this entire procedures,
These are
again,
this is because it is e-tender, there is no difficulty.
nothing. This publications and other things.
Publication, there is no
Uh,
publication.
no financial involvement. So you can cancel any number of times and
No, I am not saying that. Your lordship is adding. I am saying no financial implication.
oh yes, that is, and I'm on financial
Only
implication.
computer work is there. No financial.
Wastage of time.
That is there. What is required to be accepted, that is being accepted from the bar. But what is not required to be accepted, I will not accept. But it is apparent. Again, I am saying it is apparent, and the reasoning for the second tender is also apparent.
That's not on record, Mr.
It is on record. It's on record.
On that date, it's a subsequent document. It's a subsequent document.
One day.
He may not have, Mr. Chakraborty has annexed it, but
he has challenged it.
Yes, he has challenged because he says cancelling, you have floated another thing, another tender.
Kindly see the
because
prayers.
the earlier matter, in the earlier matter, a submission was made. There was no floating of tender in the form of an affidavit, in the form of a report, but it happened that earlier the tender was floated. I think for that he did not take that risk. He has annexed.
Kindly come to the prayers.
Prayers, yes.
Page 23. চ্যালেঞ্জ তো করেইছো, ওই জন্যই তো বলছি।
The second tender.
Second.
Yes, because he is challenging this cancellation.
What would be the effect if it is cancelled?
Which is cancelled?
This 46E, second one.
Second
one is cancelled.
48E.
46E. Second tender.
Second tender. If it is cancelled.
Lord, if my first tender is successful, then
Let's challenge both the cancellation of the earlier. So the consequence is challenging the second. That's as a consequence. Consequential prayer.
Yes.
So
and he is asking for work order.
Otherwise, he will take an objection. Yes, we have floated a tender. He has not challenged that.
No, he has said this is
why he has challenged.
This is the main reason for challenge. This is the, unless he challenges the second tender and the cancellation, the writ would be defective. But I'm to my conscience, I am saying this is apparent. 0.80 kilometer, around 1 kilometer, distance differs. These are my submissions.
Less than 10%. This is on the percentage basis, less than 10%. 14.40 was the initial. 10% is 1.44. So
yes,
less than 10%.
My lord is mathematically
less than 10%.
Sound than me.
So kilometers, it's relative matter, Mr. Day. So 1 kilometer out of 100 kilometers, 1 kilometer out of 15 kilometers.
No, because bid should be given on that basis. Bid should be given on that basis.
Any environmental implication, Mr. Day, on this?
No. That instruction.
So on what basis this calculation has been
calculation
made?
was made?
On what basis? What's the basis behind
I'm
this?
telling, I was asked.
How do we calculate?
Silt. The silt is, my lord, drained from the river bed. Silt.
At what time it is made? Can you produce those documents at the time initially you calculated the silt and subsequently you calculated the silt? Have you checked up with your authorities with regard to that? So there must be two calculation of silts.
Yes.
Initial, prior to
and why the change has
and yes. What made you think that there will be a change?
Of that 0.80.
Will be enhancing with the passage of time, not diminishing.
No, diminishes also. If the flow, yes, if the flow is larger.
So that exercise you have undertaken?
That I don't know. That is not the query. If your lordship wants, I will file affidavit. There is no difficulty of that. We are going to the broader aspect. Opening
That's the most fundamental aspect. If I go into that, floodgates will open and many things will come out, I am telling you. Because you are the best person, you have held conferences with your clients.
No,
You must be
conference
knowing-
over telephone.
You must be knowing better.
No, he said
because
that if he said ultimately it was found that the lesser length is required.
That's very easy to say, Mr. Dev, but difficult to substantiate on materials. Because if that was so, that would have been much prior to this stage.
Prior to?
I'm telling you. Has
Much.
to be.
What is
Has
this?
to be because this everything in all matters. This is from the matters I am getting. In all matters, after this,
I have no idea.
one debarment, another cancellation, thereafter this finding of this enhancement.
Changes of length. Changes of length.
Same.
Same, I'm telling you. That is why I'm telling you. Change of length, everything. In the earlier matter, if I am not mistaken, 15.50 was something, 14.40.
By the same authority.
Same authority, I'm telling you. This is the modus operandi. Participating in two tenders, one debarment, next is kept, he's within that. It's kept pending. Then the second one, he cannot be ousted. Right then, because at that point of time, he was eligible. Then cancellation on the ground of changing length. Everything. Same. And I'm not telling you all the letters are stereotyped. That is why I wanted to know, because I anticipated what would be the document. That is why I asked Mr. Mahato to bring that. And once I've seen that online copy, I've found you can use the hard copy of the other matter. It's same.
I can
Starts
have
with
the
expression
previous
as
one also.
reported by the superintending engineer. Chief engineer is forwarding to these.
My lord has finally decided any matter.
No. I have not finally decided the other matter.
So far this,
after this has come, it came to my mind that there must be something behind this.
my lord,
Because I was thinking that that was a one matter of one sort. That is what you are saying. But the same thing I am telling you. Same petitioner participating in two tenders, one debarment, another is cancellation on that ground.
my lord,
Then change of length, second tender floated.
now that in this case, he has already participated in the second tender, person to leave and result.
You will not allow him. You will not allow him because he is debarred.
No, debarred.
Lordship,
Subject
kindly
to
see
result.
the report for once. My lord, the report, my lord, so far as my learned senior has just now, my lord, read out. My lord, the report says, if I have heard, my lord, correctly, the report says, subject to, my lord, the order passed by this honorable court, I will be able to participate in the e-auction, my lord, which is going to be held on 10th of April.
That was my lord.
Ask me. The order subject to, yes, because
your lordship was pleased to allow us to participate in the e-auction process.
Subject
to. But my lordship kindly sees the report once. The report, my lord, says that I won't be able to participate in the e-auction process, even if your lordship passes an order.
No,
Even if I'm not mistaken.
No.
Sir, একবার দেখুন,
No.
আপনি তাই করুন।
No.
So let Mr. Dev.
Lordship kindly sees the report for once.
In case the stated department demands effective, the petitioner is not allowed to participate in the ERF tender.
E-tender process, my lord, is going to be held on 10th of April. Your lordship in the earlier occasion was pleased to allow me to participate.
Yes.
So I can participate by virtue of your lordship's order.
Without prejudice.
Yes,
Without
but this
prejudice,
order,
that is, they are
Lord,
finalizing.
the report says otherwise. The report says I won't be able to. Just hand over.
I am reading. In case stated department remains effective.
Right, give me one thing. I will return it to you. I will not go into.
No. Kindly go.
I will not go into that typographical mistake.
Last paragraph.
Same typographical error. আগেরটাতে ছিল
তাই নাকি? Last paragraph of the last page, second page.
Yes, of the second page.
একই কাট কপি পেস্ট করেছে
He has been allowed. And I had a talk.
Chakraborty, you may be right in one way, but they also have something
if
to
they-
say because debarment,
Lordship, kindly assume a
in case stated,
situation.
debarment remains effective.
Lordship,
Let us assume.
stay is
No,
given.
Yes, let us assume that if the debarment order is not interfered with.
No, Milord,
Right.
I am just
Then-
before that.
and if
Milord,
it
I am
is-
just before that. Your Lordship, Milord, keeps it CAV. Milord, the order is passed after Milord 10th of April. Milord, Milord, this
Why are you
question, Milord.
apprehending that?
Milord, because the
Why
report
are you
says so.
apprehending
Milord,
that?
the report says so. Milord,
Why are
my
you
apprehension,
apprehending that the
my
order will be-
apprehension is,
Mr. Chakraborty, please allow me to complete. Why are you apprehending that the order will be passed after 10th?
Milord, then Milord, I have nothing to say.
এত শোনার পর আবার দেরি হবে।
Then I have nothing to say. I am just apprehending if it is passed, Milord, because your Lordship, Milord, takes.
That is why I've told you why are you apprehending that it will
No,
be
Milord,
passed.
then Milord,
Hard দুটো আলাদা করে করবেন। Hard Mr. Chakraborty.
one Milord, small Milord.
Another judgment.
No, Milord, this is with regard to Milord, the administrative decision, as my Lawrence Senior was relying on. Milord, it cannot be arbitrary. Milord, this is Milord the judgment, Milord, court's judicial review power
Says arbitrary.
versus Milord the interplay, Milord.
Rathore.
Yes, Milord, the last judgment, Milord.
Subodh Kumar Singh Rathore.
Yes.
2024 SCC online. Thank you.
Milord, this is the judgment. Milord, may I just
So I
indicate,
think
Milord, the paragraph?
Paragraphs.
Paragraph
Paragraphs. I
64.
can tell you the paragraphs.
তোমার এগেনস্টেও যেতে পারে, ফেভারেও যেতে পারে ওটা।
I can tell you the
Milord,
paragraphs.
paragraph 64,
Uh,
I'll be relying on.
I think paragraph
64, Milord, onwards.
64.
Onwards. These administrative reasons, all these have been considered there. Sixty-four, 65, Milord.
On a given facts and circumstances of that case.
Yes, that was a case with relating to underpass. And there were some file notings also. There were some departmental notings, internal file notings, circulations, and some recommendations by some higher authority. I think that's the case.
That's the
Recommendations by some higher authority.
Yes, the minister's recommendation, that case also must be relied on here.
That case, not relied upon. It's that matter.
That is a different case.
So that is why when he said and seeing the volume, I anticipated it would be Rathore's case.
This is called knowledge.
It has taken into consideration all the judgments.
This is called knowledge.
Volume and the way he started that on this point, I anticipated that this would be.
So he has been allowed to participate. That your Lordship will indicate. And
ওটা একটা record করুন।
No, Milord, through online mode I couldn't. Milord,
anyway,
entry was not open.
No, only one thing.
Through offline.
Mr. Day, only one thing. Online mode, he could not participate, but
he has participated physically, and it would be considered.
If he is allowed to participate, whether he will accept only that offline. Please.
I had a talk. I said that his offline bid would be accepted, considered or not. It would be considered, unless otherwise anything happens, as your Lordship.
So can I record without prejudice to your rights and contentions? You have made this submission.
Yes. My lord, when I say with the.
No, I will giving that rider that without prejudice, but otherwise it would be saying that no, you have accepted him to participate. That rider will be there. Mr.
Without prejudice to other. Without prejudice.
Yes, without prejudice to your rights and contentions. And I think here also there is one clause with regard to some vesting, because there was, I think, subsequent tender also.
Yes, Milord.
Subsequent tender also, That issue was also there. What
That
would
was-
remain? What would happen to that if this is that cancellation is set aside? Here, the cancellation of the contract.
Same
was
point, my lord, taken there also.
the issue cropped up. What would happen because the subsequent award was also made?
Yes, yes, naturally,
something,
consequence will follow.
Yes.
It is a habit down.
Yes. Paragraph 134.
No, I am not on the judgment.
Paragraph 134. The notice of cancellation to be known as the issuance of fresh tender to any third party in respect of would not defeat the vested right that accrued in favor of the appellant. So even the Supreme Court went to that extent. Even if you have given to third parties
On that date,
subsequent,
on that date, Lord, it will prevail.
the appellant's right will not be getting affected. Supreme Court went to that extent in this. So what you are saying, the subject to without prejudice others, nothing. Only your prejudice.
Is it not higher?
না না higher না স্যার, ওটা ভেতরেই আছে।
হলো?
এটা ভেতরেই আছে।
And
আমি
this
exceed
is
করছি।
just being judgment.
Lord, he is inquiring whether I have submitted exceeded bid or not. Here, my lord, I didn't.
In this also?
No, no, no.
No, it's a technical bid, yes, technical
এখানে স্যার,
bid,
এখানে
yes.
দেখলেই বুঝতে পারবেন, এটা higher না।
I was just checking.
এইটা হচ্ছে আপনার বলুন। এটা ছিল
No.
Yes, soft
132
copy, they have chosen not to appear.
132
What can be done? And they have also not accrued any right, Mr. Mahato.
Yes.
They are not the highest bidder. So even if they do not have any right, and you have not given tender to the others, so then some right would have been said to have been accrued. Here, in the case of this nature, those two persons were not even necessary parties. And because I asked Mr.
আমারটা পার্টি হবে কি করে? আমারটা তো সাকসেসফুল নয়।
আসুন ওইটাতে লিখুন যে যেটা কি হলো ওটা আবার কি নট অ্যাপ্লিকেবল বলে লেখা রয়েছে
It was submitted, physical copy.
Fiscal copy, I don't have. Don't burden the court with these documents. Unnecessary documents.
Grateful.
Yes. Mr. Chakraborty, can you do, both of you can you do one thing? In a piece of paper, can you jot down only the decisions which you have relied upon in serially with these points?
Milord, those documents, Milord, those judgments which I have relied on, Milord, in the earlier order.
Please give the citations and the points. Mr. De, Mr. Mahato, you have not cited any decision.
I have
Mr.
cited,
De, have you cited any decision?
I have cited 3 or 4.
Please give in a piece of paper. Please indicate.
But I have given the copies, my lord. That is, my lord.
You have given the copies. Only put the references in a piece of paper on the points. You don't need to give judgments, decision, copies of the only. In a
Milord, I'll just hand it over to your lordship's court officer.
এই দুটো কাগজ দিয়ে দিন না ওনার। দুটো কাগজ দিয়ে দিন দুজনকে। Please put it petitioner and the you put it respondents.
দুটোই লিখে দাও।
You can put the paragraph numbers if you want to. Which yes, call the next matter.
My lord, the next matter, my lord, is the big matter. Today I will not.
Big matter.
My lord, interim order is continuing till 31st May.
But my clients are in a predicament, my lord, because
No, nothing. Interim order is continuing.
What is this matter?
There was a notice of termination of a lease without giving my lord the notice of remedy of the breach, where this honorable court, my lord, twice sent the matter back.
But
on each occasion,
without
the
explanation
authority
of the delay of each 40 years.
Each occasion, the authority concerned relied on the same material which the court had already ruled upon. The question is regarding putting up of a building in connection with a leased.
When do you want, sir?
Well, next week.
Next week.
Well, only one I'm not opposing because there's hardly any time. The only thing is, if Mr. Mahato can come ready with whatever submissions he has, then on the next day, my lord, subject to he's not using an affidavit, my lord, we can finish it off. I mean, I'm just because
I will not subject the affidavit.
Yes. Finally, because he does not want to use an affidavit, so and whatever is there.
So Mahato is there because that's consumed much of a time in one matter. Yes.
Rashid, I'm appealing for the state respondent.
Yes.
If there was a direction upon me to take instruction in connection, this was a matter pertaining to that Hashmahal.
Hashmahal, my lord, long-term settlement. There was a decision of the government long ago that it should be settled in my favor. Thereafter, nothing was done. But I approached this honorable court. This honorable court.
They were completely silent for a considerable time period. We made an inquiry in connection to the documents that were submitted before the concerned authorities, and we found that
documents submitted by Mr. Mukherjee.
My lord, and
what's the fallout?
Now, lordship, the fallout is that there is an existence of a madrasa in that particular area, and therefore the West Bengal Minorities Commissions interfered into the matter, and an offer was given to these present petitioners to go for a long-term settlement in 2016 itself. They, as per the present market value, but they didn't accept that offer, my lord. My lord, may I place the report once before your lordship? Lordship, admittedly,
now the minority commission, the madrasa is on a portion of that property.
My lord,
it's a big property. So, Milord, kindly takes up one page, Milord, page 31. Because the previous decision in my favor, I am not troubling your lordship. Kindly takes up page 31. Pursuant to this, Milord, my last representation, as per their own decision, I prayed that as per your own decision, you kindly accord permission in my favor for long-term settlement. Now, Milord, they stated this, that this, this inquiry is being done, and they will, thereafter no follow-up, stand. Even if, there are some certain portion, it's a 1 bigha and certain, kathas of plot. So even if, there is certain, their own decision kindly takes up 1 page, 20. That was a long ago.
This was the first decision that was taken in favor of the predecessor of this present petitioners in 1971.
Of the land with the unauthorized occupier, see, Nannu Khan is your predecessor.
My predecessor. Because there was a long-term settlement in favor of one company. That company, from that company, I took the possession.
A portion of that a madrasa is.
Yes, I am not on that. If it is in a portion, let them take a decision with regard to the rest portion of the land, which is in my occupation.
I will take the because after the passing of this particular order, they came before the Honorable High Court, and there was an order of interim protection was granted to them, since their representation at that particular juncture was not considered.
Have you identified which portion?
We have to make a physical inquiry. I will be very candid before your Lordship, because these inquiry.
When you can make a physical inquiry?
Lordship may pass at least 4 weeks time, may be given to me. Why I'm saying so? Because the scenario is very difficult.
Page 31 reflects, they themselves. Page 31.
Now, what can be done?
I am waiting since 70. So, I cannot say it has.
No, I am also not becoming an obstacle in this particular thing.
Page 31 suggests that their own authority, assistant secretary, is writing to the deputy secretary that yes, a physical inspection is.
No, this was because this was a letter given to the grievance cell, my lord. Since an higher authority was given the representation, this was sent to the deputy secretary public grievance cell.
So Mukherjee, please make the madrasa a party also, my lord. Otherwise, there will be a difficulty. Because
no, your lordship is not blood.
You are applied for the entire property.
That was their also decision, yes.
Now a portion of that is being occupied by the madrasa. Now the balance portion nobody knows, because there might be a dispute. They might say no. Let us assume their madrasa is on 2 kathas of land. Madrasa may say no, we are on 5 kathas of land. So any order passed behind the back of the madrasa may be in trouble thereafter also.
If my lord makes it clear that the report suggests that there is a possession of certain portion by madrasa.
Yes, because this office received a letter from Minority Commission that there is a madrasa on the government leasehold land located at such and such. And the assessed market value is not financially convenient for them for taking long-term settlement. This them is that madrasa.
No, my lord. This is the present petitioners. In 2016, they were given an offer.
You are not agreeable at that point of time.
That is their instruction. There is no documentary evidence with regard to that offer and refusal. There is no, because whatever the correspondence, that's.
May I make a humble submission?
It appears from the inquiry report dated 3rd of November, several persons occupied the said holding for business purpose.
So that's why they will take, ultimately they will take the call upon inspection. If they found that I am not in possession, the question of settlement will not arise, because the rule, suggests, the rule 219 suggests, I have to be in possession of a Khashmohol land. Then the question of long-term settlement will arise.
So I can do one thing. I direct them to complete this inquiry proceedings within a time.
Supply the report, and all interested person, if necessary, for the purpose of giving me grant, if they consider certain other persons' presence are necessary, let them also take a call, give them notice.
I give you liberty to apply again after that, because nothing remains in keeping this pending otherwise.
Yes, that's.
I record their submission that they will make an what they have said.
My lord.
They have made certain inspection. Submitted, it appears from the inquiry report that 3rd of November 2025, this was prior to this order.
This is not after this order. 29th of October is the order.
No.
Page
this
31.
Is, prior to.
No, in 2015 also there was also.
3rd of November an inquiry was made. So let them cause a physical demarcation.
Yes,
my lord.
Upon notice,
to
yes,
you and all the occupiers. And the report be provided to you. You will be can take steps in accordance.
Just one indulgence, my lord, in order to point out the last paragraph speaks of that there was a physical inquiry in 2015. for settlement.
There might be, the situation might have changed
Change,
now.
change, my lord. That might be so.
So conduct a physical
My lord,
inspection now.
I will.
The immediate
submission because the order that was passed by His Lordship, My Lord Justice Kollanjyoti Sengupta, was in 1998. Now they were silent for 28 years. The representation was made in 2000. Just to that effect that they were silent.
They
for...
have already taken into
No,
cognizance of that
The
representation.
difficulty.
Conducted an inquiry.
I will conduct.
Grateful.
Grateful.
Yes, call the list.
Item number 183. Yes. Right. For the petition. Here is the affidavit.
What is? Okay.
TSM brief is what? A complaint was made by a couple of members of the cooperative society, housing cooperative society, against its previous chairman and secretary of the society. Mismanagement and misappropriation of society's fund. A complaint was made that was not taken care of, and that was thereafter a writ petition was filed. That writ petition was disposed of by the Honorable Court by its order dated 23rd August 2024. In the meantime, the election process started, and the court allowed the election to be held. Accordingly, election was held. The board of directors were elected, but by that order, it was directed that the charge will not be handed over to the elected board of directors till the grievances of the petitioners are completely redressed, and a re-audit was directed of the audited accounts. That was to be completed within 4 weeks' time. That was not done. And the respondent number 2 and 3 were directed to take necessary action for redressal of the entire grievance. If your lordship kindly come to the page 35, the order passed in the earlier dated 23rd August 2024.
Yes.
Relevant portion is, my lord, that page 41.
Yes.
Page 41. Third paragraph. The cooperative society shall proceed to hold its election as scheduled on August 24, 2024, and shall also publish the result of the election, but such result shall not given any effect until the irregularities and the mismanagement as held by the respondent number 4 in its recent decision dated June 2020, 2024 is totally redressed. The result of the election shall be kept in the record of the respondent number 4, but in abeyance. The special officer already appointed on the cooperative society shall take immediate assistance of the cooperative audit directorate to probe into the illegalities pointed out by the respondent number 4 in its said recent decision, but positively shall commence such this order. The said audit investigation in every respect will commence and shall be completed positively within a period of 3 months from the date of its commencement. So long the illegalities pointed out by the respondent number 4 are not completely redressed in accordance with law in every respect, the special officer shall hold his office to run the management and affairs of the society. It is further clarified that if any member who shall be elected as a member of the board of the cooperative society against whom the illegalities are found by the respondent number 4, and if ultimately it is established in accordance with law, such member shall be disqualified to hold the office of the cooperative society, and necessary steps shall be taken by the rest of the members of the board in accordance with law against the member. After complete redressal of the illegalities as pointed out in the said recent decision dated June 22, 2024, passed by the respondent number 4, the special officer shall file a detailed report covering every aspect of the cooperative society relating to the running of the management and affairs of the cooperative society during his tenure, and shall submit the same to the board of the cooperative society at the time of handing over the charge, and then only shall be discharged completely from his obligation. Kindly come to page 44, my lord. 44. 44. This is the final result sheet for the election of the BOD. 9 directors were elected. That was on 24th of August 2024. The tainted directors of the previous board were not elected. They didn't even contest. As a matter of fact, the petitioners of the earlier writ petition, they also contested and lost. These 9 directors who got elected were never in the board. But Lordship, kindly see the Lordship, kindly come to page 24.
24.
24.
Turn back to page 24.
Yes.
This is the joint register of cooperative societies who passed the reasonable order upon hearing of all the necessary parties. We are not parties to that proceedings, wherein if your lordship kindly come to page 30.
Audit has been held.
Huh?
Audit conducted.
Audit is not complete. Representation were made to the authorities. Nothing is done. Things are at a standstill. There is a vacuum in the management of the society. The board of electors are not getting elected. Board of electors got elected, but the office bearers are not elected. There is no management. The tenure of the special officer long expired. The property of the society is getting damaged. There is a long outstanding dues of the property tax is due. There is no maintenance.
Why are you not completing the audit?
Your Lordship, several steps have been taken to complete the audit, but due to non-supplying, non-suppliance of the documents which are required to complete, firstly the special officer, several communications have been made. 3 queries were issued to the special officer during re-audit on 20th November 2025, 4th of December 2025.
Not supplying.
The special officer who is not charged, no?
Special officer.
Special officer, I don't know whether the tenure of the special officer was extended because it cannot be done more than once.
Special officer is in sitting.
He is also.
Lordship, we are communicating.
Yes.
Who is representing the special officer? Special officer is which respondent?
Yes,
Number 6. Who is appearing?
I appear for the election commission, Lordship. Election is held.
No allegation against you. You have held the election, but the problem is now it's at the standstill position.
But
The property is getting wasted, my lord. There are damages to the generator set.
Who is appearing for the respondent number 6?
There is no backup water pump. Every now and then.
Where?
Service
Records are lying where?
Well, that we don't know.
Your Lordship,
Either
as per the office of the cooperative society.
That got also not changed. That is that the registered office address still remains with the previous chief promoter. As the building has already been constructed.
my lord, one thing, my lord, Lordship, be kind enough to examine whether all other persons have been, because those persons are the erstwhile chairman, secretary, against whom basically all the allegations are revolving around, and against them other group of
respondents been served.
Yes,
that is very relevant.
All the records are lying with whom?
Either with the special officer or the previous chairman or secretary.
Yes.
Previous chairman or secretary, they are also the members.
If a lordship no, yes, kindly come to page 30. Kindly come to page 30.
So they are the members.
They are still members, but their membership has ceased by an order of the Joint Register of Cooperative Society, who was the respondent number 4 in the previous writ petition and respondent number 3 in the instant writ.
That is one way, but the thing is that who is in custody of those documents? Unless they are made parties, how can a direction be passed?
No, my prayer is very simple, my lord.
They are saying that we have written notices, papers are not being supplied.
My prayer.
Who is with whom these documents are lying?
It must be with
those are supplied, the audit cannot be done.
No, if it is like so far as
the members.
So far, the special officer is concerned. If he didn't have the necessary documents or the records of the society has not been handed over to him, he ought to have taken steps. And the Joint Register of Cooperative Society should have taken necessary steps against that. I don't know whether what steps they have taken.
Special officer, he is your officer.
Your Lordship, it is. I am representing the audit directorate. It's a separate directorate.
Representing
the registrar.
The state. Who is for the? Who is representing the special officer?
My lord, we say let the investigation continue. Let every steps be taken.
Sir, you are appearing.
My lord, for register.
So special officer is in your control.
My lord. My lord.
So why are you not handing over the papers for audit?
My lord.
Brief नहीं ये instruction का नहीं.
Today, my lord, I am told to appear on behalf of the registration, my lord. Earlier I didn't appear, so I have to take instruction, my lord, and to come back.
Kindly consider one fact. term of the elected board of directors is the office bearers is coterminous with the board of directors. Already more than 1.5 has the years lapsed. Then what is the harm? No, I say I'm seeking a direction, my lord. Let the office bearer be elected. Let them take over the management of the society. And so far,
I cannot. That would be amounting to modifying the order of the court. But that I cannot do. You can take steps there.
No, this is a fresh cause of action, my lord. So far as the
no, but this order for that, the order, the coordinate being directed.
Page 41.
Everything will be kept in abeyance unless audit is done.
Lords.
So now, if I direct them to take over charge, that will be modifying. That I cannot do.
That is the
If
crux
you
of
want,
this.
you can take steps there.
Then let them file a report about the present status. Where they
My lord, perhaps
records
that
are
will
made.
also not solve the problem. Kindly, my lord, see the third paragraph, page 41.
41, yes.
Why, my lord, an application for modification was not preferred? I do not know.
We were not parties, my lord.
You would have been added as a party.
We were not
Third
aware of
paragraph.
this.
The cooperative society shall proceed to hold the election as scheduled on August 24th of 24 and shall also publish the result of the election, but such results shall not give in any effect unless the irregularities and mismanagement as held by the respondent number 4 in its recent decision dated June 2024 is totally redressed. Lot of things are there, not audit. Audit is one thing. A lot of other allegations are also there. Huge defalcation of fund against the person concerned. So, my lord, if it is done and if we proceed further to hold, my lord, the office bearers election, that amounts to, my lord, violation of the order.
Nothing can be done now.
Kindly come to
So why they have not prepared an application for modification? I fail to understand, my lord. I put this question to myself.
The
তোমরাই তো এসো বেশি
On behalf of the
I appearing for the state respondent.
there is a writ petition and an application, my lord, seeking modification, which are being taken up together, my lord. My lord was pleased to grant leave, my lord, to file the writ petition today, my lord, so that it is listed along with the application.
Listed along with the application. Where is the application?
No. Application oh, application is item 211. They're both related.
Item number 211.
211, my lord.
Oh, 211 টা একসঙ্গে item number 211. Yes, who is for the applicant in 211?
Mr. Ghosh was appearing, Mr. Chittapriya Ghosh.
Where is he?
In any event, my lord, that
You ask
application.
any of your juniors to inform Mr. Chittapriya Ghosh. Yes, Mr. Bhattacharya.
Yes. Now, my lord was pleased to pass an order on 10th of March 2026, directing, my lord, the election to this particular cooperative society to be completed within a period of 1 month, my lord. Accordingly, in compliance thereof, the poll was scheduled on the 5th of April 2026, my lord. My lord had taken note of every fact, including the submission made on behalf of the Cooperative Election Commission that at least 2 months should be given after conclusion of the assembly elections to have the elections. Because they had cited that the assembly elections are ensuing. So the last elections were held in the year 2019. And here what was done was, my lord, despite election schedule being published, it was adjourned twice. And thereafter, my lord, instead of notifying a new date, they had constituted a nominated board. We had knocked the doors of justice in the first round of litigation, my lord, challenging this action, and they were, my lord, trying to have an election of office bearers, my lord, which we challenged. So, my lord had directed, my lord, kindly takes, my lord, page 106, my lord, of the writ petition.
106.
My lord. My lord's judgment and order starts at page 106, where the relevant paragraphs will be paragraph 16, 45 and 50. Page 110, my lord, will find para 16. The submission of Mr. Naik, my lord. Mr. Naik submits that repeated attempts were made by the Cooperative Election Commission to conduct the elections, but since the police authorities informed the returning officer that adequate police personnel may not be available on the scheduled date of nominations as well as on the date of Board of Director election of SKUS Limited, the election had to be adjourned on 2 previous occasions. He further submits that in view of the ensuing assembly election to the state of West Bengal, at least 2 months' time after conclusion of assembly election be given to the Election Commission to conduct the said election. Thereafter, my lord kindly takes pain to, my lord, take para 45 of my lord solemn judgment and order at page 117. The version of the state, my lord, has recorded. The learned advocate appearing for the state on instruction submits that the respondent numbers 10 and 11 shall render all assistance to the Cooperative Election Commission for the purpose of conducting the election of the said Shomiti. Such submission of the learned advocate of the state is placed on record. I had also, my lord, shown a decision of the Honorable Supreme Court, my lord, where, my lord, central forces were deployed. And in fact, my lord, when that suggestion, my lord, had fallen from the Honorable Court, the state said that no, we are ready and willing, my lord. And thereafter, my lord, kindly takes para 15, the directions are para 50, page 119. The directions are contained therein. And this was, my lord, specifically in view of the stand taken by the Cooperative Election Commission and the state. The court is inclined to dispose of the writ petition with the following directions. The ARCS and the returning officer of the SKUS, the assistant returning officer being the respondent number 5 and the Cooperative Election Commission are directed to initiate the process for conducting the election of Board of Directors of SKUS forthwith and conclude the election as expeditiously as possible, but positively within a period of 4 weeks from the date of receipt of a server copy of this order. Upon issuance of the election notification, respondent number 5 shall thereafter send a communication to the SP Birbhum and OC Chandrapur district, being the respondent numbers 10 and 11 respectively, for necessary police assistance.
Immediately upon a request being made by the fifth respondent, the respondent numbers 10 and 11 shall take necessary steps for deployment of adequate police personnel on the dates of nomination and election of board of directors as per notification that may be published by the respondent number 5 and shall also render all assistance and cooperation to the respondent number 5 to 7 for the purpose of free and fair elections to the board of directors. And with the observations, my lord was pleased to dispose it of, my lord. Now, thereafter, my lord, the election schedule was published. My lord will find at page 123, because my lord, while arguing, I had demonstrated that a total period of 14 days maximum was required. So, considering that, my lord had given them, my lord, the window of one month, 4 weeks. So, the date of polling, my lord, was earmarked on the 5th of April, my lord, and my lord, the issuance of nomination papers, scrutiny, etc. These dates were also given: 23rd March, 26th March, 27th March, etc. And 5th was, my lord, the date for polls and counting and publication of the results. Now, what happened, my lord, in the interregnum? Now, my lord, a modification application was filed. A modification application was filed on behalf of, my lord, the society, where they said that no, please kindly modify the order, because there might be a possibility of the elections may not be held, that the elections may not be held peacefully. So, my lord will find, my lord's order at page 162, my lord kindly takes a note of the date. This is very important, 25/3/2026. This is an application praying for modification of order dated 10th March 26, passed in WPA number such and such. The cooperative society has filed this application on the ground that in the meantime, the notification for assembly election to the state of West Bengal has been published, and the Cooperative Election Commission might face some inconvenience for conducting the elections as per schedule announced by the Cooperative Election Commission. So, it is the Commission's cause, my lord, being advanced by way of the modification application. On a query of the court, Mr. Nayak, representing Cooperative Election Commission, submits that till now, Commission has not faced any difficulty in proceeding with the conduct of election as per schedule announced by the State Commission. He submits that 23rd March 26 and 24th March 26 were fixed for filing nominations, and 31 nominations have already been filed. This is very important, my lord. He submits that the date for scrutiny of the nomination is fixed on 26th of March, and the date of withdrawal as well as publication of the list of contesting candidates is fixed on the 27th of March. Mr. Ghosh, representing the applicant cooperative society, submits that the cooperative society will render all cooperation and assistance to the Cooperative Election Commission in the matter of smooth conduct of the election. It is made clear that pendency of the application shall not discourage the Commission from proceeding further with holding of the election as per schedule announced. So, when this happened, my lord fixed another date, because my lord was of the view that the Honorable Court should be keeping this application pending, so that in case there is any difficulty, the Honorable Court will step in and pass necessary directions. Now, my lord, in the teeth of such facts and in light of such order, my lord, now what happens, my lord? The mischief gets unraveled. Now, my lord, this was not indicated. This is, I understand, my lord, this is definitely a backdated letter, page 164. But kindly marks, my lord, the date 19/3/2026. So, this is written by the OC of Chandrapur Police Station to the Deputy Registrar. Prayer for rescheduling of general election of Laujo Samabay Unnayan Samiti. Due respect, I would like to state that the general election of Laujo Samabay Samiti is scheduled to be held on 23/3/26 to 5/4/26. In this connection, it is humbly submitted that at present adequate force deployment is becoming very difficult. Mentionable that MCC is in full swing in connection with upcoming Legislative Assembly election. Hence, the available force is already engaged in multiple essential duties such as interstate Naka checking, area domination, execution of warrant raids, rowdy visit, vulnerable voter visit, confidence building measurement activities, SST duty, FST duty, sector area visit, etc., and other election related law and order responsibilities. Due to this heavy engagement, it is not feasible to spare sufficient force for the smooth conduct of the said election. Apart from that, it is learned from verified source information that there could be an apprehension of law and order situation which may take place over the issue of said cooperative board of director election, not only on the day of election but beyond that. Therefore, as per assessment, the situation is quick, sensitive in that sense. In view of the above, therefore suggested that matter may kindly be considered, and if possible, the election may be rescheduled after completion of the ongoing MCC period in connection with the Legislative Assembly election. So he is, my lord, also advancing the initial submissions made by the Cooperative Election Commission, my lord, which stood recorded in my lord's judgment and order, my lord, at para 16, my lord. Now, thereafter, my lord, in attempted sanctimony at page 165, the returning officer sends a letter to the SP on 20th of March 2026. So this is, my lord, a day after the letter of the OC Chandrapur. So he says that I would like to inform that the Honorable Justice Hiranmoy Bhattacharya has given direction upon you, respondent number such and such, to provide necessary police assistance with a paragraph number 50, Roman 1, Roman 2 and 3. In compliance with the order of the Honorable High Court, election schedule has been prepared and served to all stakeholders, including you. Meanwhile, I have received prayer of OC Chandrapur, dated 19/3/26, for rescheduling of election of Laujor. And after West Bengal Legislative Assembly election, it is not known to me whether you are aware of the letter dated 19/3/26 issued by the respondent number 11 Chandrapur or not. Non-compliance of the order of the High Court may attract contempt of court. In this background, being the returning officer, would request your good self to provide adequate security arrangement to conduct election as per schedule. If not possible, state may approach Honorable High Court seeking leave through proper channel. So this stood culminated, my lord, in the application for modification filed by the society. So they were persons operating from behind the veil. Now thereafter, my lord, the SP keeps this, my lord, in limbo. The communication dated 20th of March 2026. And he suddenly wakes up from his slumber 24 hours, my lord, prior to the date of polls. On the 3rd of April, page 166, my lord will find, he suddenly responds by saying non-availability of police personnel in connection with election of Laujor SKUS. Reference to the above, this is to inform you that at present, police personnel are extensively engaged in various election-related duties such as SIR, security observers, maintenance of law and order during political program and meetings, nomination filing duty, Naka checking, static surveillance, such and such, VIP movement, training, security of polling personnel, and security of judicial officers engaged in SIR amongst other responsibilities. Due to these commitments and the enforcement of the MCC in connection with the ensuing assembly election, police personnel are not available to provide the necessary security arrangement for the said election. In view of the above circumstances, it is requested that election of Laujor SKUS may be deferred for the time being. It is further requested that after completion of the Assembly election 26, matter may be taken up on top priority basis for providing adequate police personnel to facilitate the smooth conduct of election. Now, suddenly, my lord, on the receipt of this, my lord, at the threshold of the date of polls, 5th was the date of polls, 4/4, my lord, the returning officer suddenly, my lord, again postpones, my lord, the date, the polling. সমিতি অফিসে নির্বাচনের কাজ করার সময় দেখেছি ওখানে সদস্যদের মধ্যে চাপা উত্তেজনা কাজ করছে। দুবার ভোট বন্ধ হওয়ায় প্রত্যেক সদস্যই বিরক্ত। তার প্রভাব আমরা দেখতে পাই গত ইংরেজি 26/3/26 তারিখে স্ক্রুটিনি চলার সময় সামান্য কথা কাটাকাটির সময় কিছু সদস্য আমাদের তালাবন্ধ করে দেয়। গত 19/3/26 তারিখে ওসি চন্দ্রপুর পুলিশ ফোর্স না দিতে পারার ইলেকশন শিডিউলের পরিবর্তন করার কথা বলেন, কারণ ভোটের দিন ও ভোট পরবর্তীতে আইন শৃঙ্খলার অবনতি হতে পারে। এসপি স্যার অদ্য 4/4/26 তারিখে পত্র মারফত জানিয়েছেন আগামীকাল সমিতি নির্বাচনে পুলিশ ফোর্স দেওয়া সম্ভব নয়। এমত অবস্থায় আগামীকালের নির্বাচন হলে যে বিশাল জমায়েত হবে তাতে যে কোনো সময় অপ্রীতিকর ঘটনা ঘটতে পারে এবং আইন শৃঙ্খলার অবনতি হতে পারে, তাতে এআরও সহ পোলিং পার্সোনেল ও সমিতির কর্মচারীদের ক্ষতি হতে পারে আশঙ্কা করা যায়। সেই জন্যই আগামীকাল নির্বাচন করতে গেলে যথেষ্ট সংখ্যক পুলিশ ফোর্স না পেলে অবাধ ও সুস্থ নির্বাচন সম্ভব নয়, তাই অনুরোধ জানাই। And my lord, this is the situation. On the basis thereof, my lord, page 168, the polls have now been adjourned, my lord. Despite, my lord, a specific judgment and order to that effect, and despite the honorable court, my lord, being magnanimous enough to keep the application for modification of the order pending for facilitating and fostering, my lord, free and fair conduct of the elections. So this is the fact situation, my lord. I say, my lord, this is an act of, my lord, absolute contempt, my lord, which has been orchestrated by the Cooperative Election Commission because it is, my lord, from day one, my lord, at the time of submission, my lord, of when the writ petition, my lord, the earlier writ petition was being taken up, my lord, the same gets reverberated, my lord, through the various other authorities, my lord. The police was advised by the returning officer to seek a clarification from the honorable court. Now that is being filed by the society by way of a clarification application. And now, my lord, this particular, my lord, this conspiracy, my lord, to ensure that elections are not held. Now, my lord, I will be, my lord, just relying on, my lord, the proposition of law, my lord. First is, my lord, it's a judgment, my lord, of an honorable single bench, my lord, of the Punjab and Haryana High Court, my lord. Yes. It's reported in 2024 SCC Online, Punjab and Haryana, page 2847.
Yes.
Paragraph 4 and 5. That categorically lays down the ratio is, my lord, MCC cannot be cited as a ground for complying with judicial orders. This court, para 4 I will be placing, this court has also come across number of cases where the states of Haryana and Punjab as well as Union Territory Chandigarh have been taking a stand that orders of the High Court could not be complied with in respective cases on account of prevalent model code of conduct. Therefore, it has become necessary to clarify here that no code of conduct issued by Election Commission of India or any order or instructions issued by any other authority can be permitted to stand in the way of execution of the order of the High Court. Authorities are fully authorized and are under a legal duty to execute orders of the High Court without any specific permission from or intervention of the ECI. Therefore, this situation is being clarified by the court that states of Punjab and Haryana as well as UT Chandigarh shall comply with the orders passed by the High Court, irrespective of enforcement of the MCC on account of Lok Sabha elections or any other election, unless the orders passed by the High Court are actually and specifically stayed by some appellate court. A copy was also sent to, my lord, the Chief Secretary. So, my lord, this is one, my lord. The second, my lord, that I will be, my lord, referring to. Yes, it's a judgment, my lord, reported in 2003, volume 1, West Bengal Law Reports, my lord, Calcutta, page 213. My lord, may kindly take my book, my lord. Citation to bole dao Chitu ke. Paragraph 6, my lord. Paragraph 6 and 7, my lord, are the relevant paragraphs. It is therefore settled law that the second writ application is maintainable for implementation of an earlier order of the writ court. The court must issue proper directions for proper implementation of previous directions. Where there has been an order, the order must be complied with. An act done in willful disobedience of a court order is not only contempt, but also an illegal and invalid act. The language used in Article 226 of the Constitution of India is couched in comprehensive phraseology, and the said article recognizes a very wide power on the High Courts to remedy injustice whenever it is found. It has been held in Begun Kodor High School's case, reported in 96-2 CLJ, page 349, that it was the duty of the High Court to see that the order passed by the High Court is carried out by any means whatsoever, otherwise a constitutional remedy under Article 226 will become infructuous. This, in fact, was again relied upon, my lord, in Indrapuri Studios case, my lord, which is reported in 2003, volume 4, Calcutta High Court Notes, page 148. The relevant paragraph is, my lord, para 35 to 37, my lord. My lord, I'll just hand up my book, my lord.
Para 35 to
37. Compare করে নিয়ে ম্যাচ করছে তো হ্যাঁ para 35 this writ petition has been found para 35, my lord.
Yes.
Yes. This writ petition is virtually a petition before this court for enforcement of the order passed by this court in earlier writ petition. A second writ petition for enforcement of the earlier order is very much maintainable. In the case of Vivekananda Mondal, one of the one that I cited, my lord, thereafter, my lord, kindly takes para 37. For the sake of prolixity, my lord, I am not placing para 36 because 36 Vivekananda Mondal I have already cited. Para 37, the Supreme Court in case of Devkinandan Prasad versus State of Bihar, reported in AIR 1983, Supreme Court page 1134, entertained a second writ application under Article 32 of the Constitution of India and passed specific order directing the authority to do what was earlier directed by the Supreme Court on the first writ application. So, my lord, insofar as, my lord, the writ petition is concerned, I say, my lord, this is, my lord, a futile misadventure by the respondent authorities acting concertedly to ensure, my lord, that orders passed by the honorable court, my lord, is violated, my lord. They're trying to give shape to what was initially submitted by them, my lord. And my lord can, in fact, my lord, also initiate suo motu rule of contempt, my lord, against, my lord, these are the errant authorities. But I am here now, in so far as the writ petitions, there, my lord, I will be praying for sequestration of their properties. This is, my lord, a contempt on the face of the court, my lord. And during subsistence, my lord, when the honorable court was monitoring the situation, my lord. So my lord, I say, my lord, if they are now, my lord, so miserably preoccupied, as they have miserably tried to demonstrate, but the central forces are there already, my lord. The MCC is in vogue. My lord, may kindly direct, my lord, now only the polling dates are remaining. The polls are only remaining. Everything else is complete. Let them have the poll, my lord, within the 12th of April.
Yes, Mr.
Lordship, I have most humbly submit.
My lord, I have also made the union a party here, my lord, since I have made a prayer for deployment.
Submission.
Yes,
Lordship, I most humbly submit. Lordship, we have no.
I will come to you.
My lord, with due regard to my learned friend's contention, my lord, I most humbly submit. My lord, we have no objection at any point of time.
You can conduct election.
Yes.
When can you conduct election?
As you lordship, because we want protection to say.
Please give me a date.
Uh,
Please suggest a date when you can conduct election.
Only one thing, lordship, kindly is I obviously lordship would be kind enough to give me few hours, at least few hours time, because time that depends upon the consultation or also information to ARO, police, polling personnel, RO, and election commission. My lord, they are doing constantly at least
the number of force that you require for the purpose of conduct of this election.
Well,
Have you
that
made
is
any assessment?
that is up to the administration to see no untoward incident takes place.
Assessment?
I have not, my lord, taken instruction on that because we depend upon police said that they will render.
What is required for you to conduct the election?
My lord, my instruction.
How much time you need?
That, my lord, lordship, I can come back and inform otherwise of my own, my lord, here and now. If I say, my lord,
no, give me an approximate time.
Tomorrow I can at least, my lord, let me have some breathing time to take instruction. But one thing I make it clear, at no point of time, because we said we did not have any problem. We wanted support from the concerned authorities. They, in writing,
don't have any choice about which authority can support you.
Yes, the SP and others, they have said, my lord,
if they cannot support you, you don't have a choice.
We don't have, because you depend upon your state said.
So only want security. So that it is
tomorrow,
in a peaceful manner.
Tomorrow, let me come back. Come tomorrow.
Yes, I will come back to you.
Yes, let me come tomorrow, because we are fully lots of one submission.
This letter.
What
of
on third, four. Lots of kindly come to
page 164 letter. It was addressed to the returning officer. You are representing the returning officer.
Yes.
When your returning officer received this letter, 19th of March 2026.
164, lordship.
Page 164.
Yes. 19th of March later, lordship.
Yes. When did he receive? The returning officer received this letter.
That is not mentioned here, lordship.
No, that is not mentioned. Please take instructions when the returning officer.
And Miller, kindly see 20th, next page.
Yes.
Next page.
20th is the returning officer writing to the SP.
Yes.
I want to know when this letter of 19th was received by the returning officer.
Below 19th writing letter and immediately on the very
this letter when you
below only there is no date gap because 19 lordship the letter of the IC and 20th immediately we reacted. So 20th very next day we have written. So in between maybe in the afternoon maybe
on 19th you received or 20th you have received the letter of the OC.
Obviously as it appears and immediately
Prevented you from making pointing out to the court on 25th of March at page 162 of this fact.
That lordship kindly appreciate. I was representing the election commission and matter was taken up.
Prevented you from bringing to the notice of the court of this letter on that day.
That letter, my lord, we were not received here in Calcutta because they filed this matter immediately.
When you have received this instruction.
My lord, also this is our year when Aru. My lord, this is 20th, and my lord's order was on 25th.
Yes, subsequent there too.
Subsequent there.
And if I recollect that I asked you whether the you need central force, you said no.
Yes, because we had to, depend because there are several other elections also we are holding and they are protecting.
So I take it that you are not informed of this order, this letter.
I will take clarification on this, lordship. This particular query, my lord, let me take clarification and come back.
Yes.
I will come back on this.
Because you said that you do not have any difficulty. So
because we lordship kindly, I most my lord humbly submit that we depend upon the state machineries, no doubt about it. Law says so.
Cannot provide.
And no, they say they undertook your lordship. There is the averment. They said that yes, they will.
So now, if the state is not in a position,
that will not they will. I cannot.
Several other duties.
I cannot. I cannot say anything on behalf of the state.
So you do not have any choice.
We want.
If the state cannot give the other forces.
That will not let them clarify. We don't have any choice. We want protection of our officers.
Don't have any choice with regard to that. Yes. Now,
Lordship, most humbly, I submit to Lordship that we have no intention to violate the Lordship's order, Lordship. Situation compelled us.
Can you provide the forces now? The date when the
Lordship, I Lordship requested the authority. Lordship, it appears from the letter of the Superintendent of Police at page 166. We requested very humbly to defer the election in view of the certain reason.
That's one thing. That's your request.
Lordship.
I am asking you, can you provide the force on the date when the Cooperative Election Commission will be fixing prior to the assembly?
Lordship, that is the difficulty. Lordship, I have received a report. Lordship, I am
not forcing you. If you have any difficulty, I will pass other orders. I will entrust other authorities. But I am giving you a choice.
I have from the reports which I received from the SP.
So they have said that they cannot.
That is before election. It is very difficult.
Difficulty is one thing. Whether you can provide. Difficulty is.
I have to take instruction. I have to take instruction.
May I now to make my submission in item number 211, my lord?
Yes.
Mr. Sai was appearing on that day. In that
my lord, I have written instruction from the SP Birbhum, my lord. May I allow to submit before your lordship?
Yes, submit the report.
My junior is there.
কোথায় রিপোর্ট আছে দেখে দাও না দাও রিপোর্ট কোথায় তুমি দাও না My lord, this is a report therefore এখানে এসো সামনে এসো কি আছে রিপোর্ট দেখে তোমার অফিসটা আমার ভিতর চাপিও না
It seems Mr. Nayak, the state cannot provide you the force. State cannot provide you the force. Union is a party here.
Yes, we have made the union
who is representing the Union of India? You are representing. Can you provide force for the election? Please take instructions. Please assess the situation. If the state cannot provide, and you take a final instruction. If you can provide, well and good. Otherwise, I think I will have to consider other things. This is the last opportunity which you are getting.
One more submission, Your Lordship. Lordship, if that is subject to Lordship approval, Lordship fix any date after 6 April, 6th May, Lordship, any date, Lordship.
I want before that.
Lordship.
Please suggest a date.
I have to take instruction, my lord.
My lord, one small.
Command the court.
No, certainly not.
Yes.
No, I just.
So when this court specifically directed you, you have to do that on the modification application. You cannot go with your own dictates.
Because of the certain difficulties, Lordship.
I'm not forcing you.
Situation compelled us to do so.
Forcing you. I'm not forcing you. You can
My lord, please keep this matter by tomorrow. In the meantime, I will
perform your other duties. I'm not forcing you. I'm only giving you a chance. Whether you can provide some of your officers, may not be the entire thing. You can say, yes, I can provide one or two. I want the assistance of others. Please make that.
Lordship, I will take instruction.
If you can spare one or two of your officers, others can be taken care of.
My lord, one small submission can I make, Lordship? So far as today's petition is concerned, and also on the last day's petition and submissions are concerned, Mayor Sarmaji's conjecture, they said the election commission doesn't want. But today, my lord, when we said we are fully prepared, and we also, my lord, supported the contention.
What prevented you from bringing to the notice of the court of this?
That was in the hand also of the state. My lord, kindly excuse me, Lordship. We said
on 31st of March.
Only one clarification.
I did not point out this fact.
I will take clarification. My lord, 28th is the letter, and 25th, my lord, was pleased to take up the matter. Now, my lord, in between Saturday, Sunday, perhaps was there 3 days holidays.
What happened on 31st?
My lord, I will take instruction. My lord, I don't.
31st was also there prior to the date fixed for poll. Why you are sitting tight after getting this letter of?
And my lord, kindly see our letters also. My lord, our letter we intimated with the request. You ensured. My lord, one thing.
You may have taken steps, you may have written letters, but when you are finding this, the OC is writing letters. What prevented you from mentioning this matter before the court, bringing to the notice of the court? Yes, I'm facing this difficulty.
My lord, that we have said. My lord, not in a very, in so many words. This letter might not have been, my lord, referred to because it was not in my instruction. But
No,
we are facing.
Brought this back to the notice of the court. You could have mentioned this matter.
That day, my lord, it was not known. I will take instruction. No, I will come back tomorrow. Why it was not intimated?
Anything before the elections?
What happened, my lord, when they are moving the matter, serving tomorrow, and my lord, election to be held at Birbhum. And my lord, tomorrow, my lord, Mr. Bhattacharya is moving the matter today.
Only because you could not perform your duty within time, and you have cancelled that. But also in content, Mr. Naik. How could you defer the election when there was a specific direction upon you to do so?
Now, my lord, we tried.
Aware on two occasions, two earlier occasions, also the police could not give you assistance. At that point of time, there was no elections. There was no assembly elections. So it appears to me that the state machinery cannot give you assistance for holding this, because earlier two occasions, now they are taking the plea of assembly elections, which was not on the earlier occasions. Those were not fact, but you have to postpone it. Or for
let me come with specific instruction how and what is the date. As my lord desired that as soon as possible the date has to be, my lord, fixed up. Tomorrow, one second.
Tomorrow at 10:30.
Yes.
You are getting some.
Your lordship directed me. My lord,
at 4:30 today, I am keeping it 10.
Very well, lordship.
Your lordship directed me to take instruction.
Lordship,
one humble submission, in lordship, that these days after the announcement of the election, the police authorities will be controlled by the ECI, lordship, Election Commission of India. He is the control.
If you want, I can implement the Chief Election Commission also as a party.
Better.
They can also provide that, leave some of their officers. If you want that, I can also do that. If you are inviting that, I can also do that.
Just I humble my submission.
No.
Thank you. Yes, Ashutosh.
No. Hope not.
Then Mr. Naik, you are getting some.
Lordship, I am taking instruction because we want to, Lord, we don't like that it maybe it will be delayed in any manner, but we want support. Our personnel
will be getting now.
That's what we want protection.
Support will be, since you insisted the state force, I did not pass it.
No, Lord, we because we depend upon it, Lordship.
So I asked you, You are confident, no, the state machinery will give
Obviously,
you
they will do.
on the day when the
They also
modification
undertook, my
application
lord.
was being taken up. I asked you,
Lordship.
you are confident of the state machinery. Now you see,
Because
they have backed out.
we have conducted, my lord, as many as 1,600 elections in the meantime, depending on state forces. How can I similar at this juncture? We shall not depend. They also undertook,
From
yes.
the previous experience, you should have told that
Most
this
unfortunate
matter
we have
also-
faced it, lordship. Because it's not a huge society. We made all arrangements. Everything was ready.
You can also make your assessment how much forces are necessary, because you are conducting the elections regularly in a regular manner, as you are saying. So you must be also making an assessment.
Only 709 members.
And one more, if my lord allow me to say, though it is not relating to this, only one thing, lord, may I submit? Now, MCA, we are under, now election date has been announced, we are under MCA, my lord, there is no doubt about it. Everybody knows. Mr. Bhattacharya's client is one person, is why so much interested, the election has to be done within a week.
Mr. Nayak,
I do not know, my lord.
This submission comes from the Cooperative Election Commission.
when
The
you are
bias and
inclined
the
to hold
malice
that-
Because-
is more apparent.
Because we shall say, because we are also
Okay, file one
protecting
of the
other
affidavit, sir.
elections. We are also
Affidavit, sir.
participating there.
service filing
perhaps it has gone down that pursuant to a letter issued by the assistant returning officer, the election was adjourned, my lord. But it is the returning officer who adjourned the
Returning officer.
my lord, at page number 168, my lord. Assistant returning officer made a request to the returning officer to take steps at page 167. Now it is the returning officer, page 168, who writes to the Secretary Cooperative Election Commission, and it stated that the election scheduled on 5th of April is adjourned until further.
The return. ওই একসঙ্গে থাকে yes
and my lord, may I get back the books, my lord?
yes please take back, please bring it tomorrow. Bring copies.
So Lordship, we kindly enough to take care so that we can get the order copy in the surveyor tonight, Lordship.
You have heard Mr. Naik?
No, we are communicating it. Because the
you can
distance.
communicate. Now it's
In fact, our role is very.
Live streaming is also going.
No, that
no difficulty.
That is here, Lordship. We are communicating, and
Yes. Call the next matter.
Deeply obliged, my lord.
This along with can
211. I think
211. List this matter. Yes.
185, Lordship, I am for the state.
Yes. Yes, Mr. Bhattacharyya. What is this matter?
Took a loan in the year 2004 and has not returned any money.
Yes.
So therefore, after an order was passed under section 1839 of the West Bengal Cooperative Societies Act, directing her to make payment. She did not pay. Thereafter, the assistant register officer, certificate officer, issued a notice, heard the certificate case, and passed an order.
Shall not be deducted from the retirement benefit.
Yes, it shall be deducted because she has only now 10 months.
Oh, you are the cooperative bank. Who is for the private party?
Nobody, they are now not appearing, my lord.
I am for the state, Lordship. Lordship give direction to take instruction.
But
block.
Lordship, they have wrote a letter.
There is an agreement under section 59.
Yes, my lord, that is there.
Where is that?
That is there. That is.
Where is the agreement under
Yes, my
59.1?
And
Yes, my lord. The agreement is in page 34 of the.
34.
Yes.
Yes.
Attachment of salary. Their intention for attachment of salary. The block medical officer also ready to attachment of salary. 2/3 of the salary they are ready to attach from the next.
From the retiring gratuity also you have to recover.
Yes.
Otherwise, from the salary, 3 months service is left with.
10 months, my
So
lord.
10 months salary, from the salary of 10 months, that can be deducted.
75,000 salary they have brought. What 2/3 is 50,000 per month they have deducted from the.
No, we have not deducted anything because nobody.
The attachment of salary from the attachment of salary.
What is the salary?
75,000.
Where he is employed?
Block medical officer.
Block BMOH.
BMOH under BMH.
Under.
Already you take steps under section 59(2).
Yes,
that's the only direction that can be passed.
Filer may give a direction to the BM respondent number 2.
Respondent number. Who is the drawing and disbursing officer?
Yes.
Drawing and disbursing officer. Who is the drawing and disbursing officer?
Block medical officer respondent 2 is a block medical.
Yes.
Block medical officer.
Yes. And I understand that friend has advised him also to act. And so after 7.
The respondent number 2 of the treasury officer shall deduct.
Treasury is 5.
Treasury 5. But the treasury officer cannot deduct initially because the
BMOH is the drawing and disbursing officer.
Yes.
The
Page number
Log BMH to make deduction.
Yes.
And
Next.
for 9 years, it didn't make.
Thank you.
Item number 186.
But I'm for the petitioner, I'm seeking an accommodation.
Why? What is this matter?
As per your lordship in direction, we have handed over all the keys and
To cut it short, Lordship, this is that election where, in spite of election, officer elected.
Another election. Too many election matters. Not today. Yes.
Lordship,
Next.
Lordship.
I am for the arrest respond number 6 to 20. I'm led by Mr. Mitro.
Oh, yes, that matter. Who was making
Yes.
mistake? Who was making submission?
Yes.
Mr. Mitra is supposed to.
Okay.
Yes.
We had on the merits also, we had made the submissions on the last occasion. But today, I think the understanding was that the respondents would address your lordships.
Yes, Mr. Mitro, I think will be making some.
May it please your lordship. My lord, the election has been held. My lord, all the persons, my lord, who had been nominated had been elected. Not one had. Therefore, my lord, the process which was sought to be challenged, my lord, that has been completed. Your lordship will please.
So your eligibility has been challenged.
The really, what happened was this. I tell you, lordship, kindly see the prayer first. Prayer in the writ petition.
In which writ petition? 1013 of 2026?
Yes, my lord. Kindly come to page 27. For setting aside the final voters list.
I could not find out because
that is
become a bulky one. Applications, affidavits, reports.
See, a lot of things. Well,
I've got now.
Page 27, well, I don't know whether the pages will tally. The first, the prayer B is setting aside the final voters list dated so and so, published for the election to the board of directors. Then, Malad,
so according to you, this has become infructuous now.
Absolutely infructuous, because Malad, the voters list has been prepared in terms of Malad, the act itself, and Malad, in fact, the inspector was directed to file a report with regard to the voters list. Well, I tell you, Lordship, what happened. Kindly take my affidavit in opposition. The case has been made out in the first few sub-paragraphs.
Affidavit in opposition by 5, you are 5 and 6.
7 to 26.
7 to 26.
Paragraph 3 at page 2.
7 to 26, yes.
Yes. Well, kindly come to
paragraph
3 at page 2. Well, sub-paragraph A and B, well, they are preliminary paragraphs, need not be looked into.
Yes.
Kindly come to sub-paragraph C. In paragraph number 7 of the said writ petition, the writ petitioner alleged that as many as 392 persons were inducted as shareholders members of the society on 27/8/2024. And the same statements have been affirmed as true to his knowledge. Assuming but not admitting that 392 persons were inducted as shareholder members on 27/8/2024, till date, no challenge has been thrown by any member of the said society with regard to the said membership before any forum of law. After the election process of the said society started, and after publication of the final voters list, The petitioner has filed the instant petition. The only one person has challenged. And my lord, that too, not my lord when they were included, but my lord after the voters list has been published and the election process has started. That will have some significance. Once the election process has started, whether my lord this writ petition could have been filed challenging my lord the voters list. Then my lord, next subparagraph, it is stated that the election process of the Haldia IOC So-and-so Society Limited has already been started. Nomination papers has been filed for contesting the election of Board of Directors. The list of valid nomination has been published on 29/1/2026, and final list of valid candidates after withdrawal of candidates had been published on 30/1/2026. The election of the Board of Directors of the said Haldia IOC Welfare Election Credit Society is fixed on 10/2/2026. And in fact, my lord, election has been held. Hence, since the election process already been started, and if the petitioner is aggrieved by any action of the election authorities, an election dispute is required to be filed before the West Bengal Cooperative Election Commission. In fact, another person, namely so-and-so, has filed an election dispute before the West Bengal Cooperative Election Commission on the self-same cause of action.
So an election dispute application has been filed, petition has been filed.
Somebody has filed it, my lord.
Challenging the self-same election process.
Yes. But my learned friend's client, my lord, instead of my lord proceeding that way, in fact, he had two options open. He had first option open to go before the registrar under section 102.
Challenging your membership.
Challenging membership. That should have been the first dispute. This was not raised. Once the election process has started, then my lord, my respectful submission
to you, cause of action for challenging the membership was long back.
Long back. And my lord, if he has not challenged that, then he will be precluded from challenging it, my lord, now before the writ court. Firstly. Secondly, my lord, once the election process has started, then my lord, under the constitution, you cannot come before the court. You have to wait until the election has been held. And then only you challenge the result. So, my lord, this particular, that is why I submitted to your lordship that this petition has become infructuous. Now, my lord, let us get into the merit of the controversy. I say on merit also, perhaps my learned friend's client will not be able to sustain this. My lord, kindly come to page 5, subparagraph 4 of this is of paragraph 4. Paragraph 4, subparagraph Roman 4, small Roman 4, paragraph 5. Kindly see, my lord, who are the members whose membership are being challenged. Kindly see. The respondent number 7 to 26, immediately after joining the service of IOCL on different dates, more specifically, the respondent number 7 joined in 1998. Respondent number 8 in 2015. Respondent number 9
dates of joining the service.
Service. And my lord, by reason of my lord, automatically they become members. And therefore, my lord, and in fact, my lord, the cooperative society had accepted them as member. Month by month, my lord, membership fees had been, my lord, deducted since 1997 in case of one, 2015 in case of another, 2000, then 1997 in case of a third, 2019.
To you, they automatically became members and membership fees are being deducted.
And also, my lord, they are being advance loan as members. No person
the benefits as a member.
Or as a member.
All the benefits.
All the ones. And my lord, it is not that for the first time I came up before as for claiming my membership today. From my lord 1997, the person who had been engaged, my lord, he had been clamoring for his membership. The person who has been, my lord, inducted as a member in 2019, he had been claiming, rather he became an employee. Since that date, my lord, they had been clamoring. Unfortunately, what happened was this: the board of directors, which was operating at that time, completely ignored this. And this was one of the grievances, my lord, made before, my lord, the registrar, and also that is why an inspector was appointed by, my lord, the authorities for the purpose of finding out with the truth of our contention. And he found that we are all on the register as, my lord, employees of the IOC since that date, since the date of our appointment. And he has given a report to that effect. And thereafter only, my lord, these persons have been, my lord, accepted after, my lord, that board of directors had their time has expired. And then, my lord, my lord, after that was superseded, my lord, their case was taken up, and it was found that they are justified in their claims, and therefore, my lord, they were put on the board. But in fact, my lord, membership had been throughout membership had been acknowledged. That is why, my lord, nobody came forward to, my lord, object to it, excepting my learned friends, one single client. There are 792 members. These are 382 or some such members who are asking for membership. And, my lord, nobody had objected because, my lord, their claim is genuine. And that has been so found.
Any certificate is issued to the members. What's the procedure? How do you know that you are a member?
My lord,
You may automatically become a member.
I tell you, lordship.
Any certificate is being issued or anything?
My lord, there are two things. First of all, my lord, the cooperative society's rules, the rules of this particular type, the bylaws.
Yes.
There, my lord, it says the membership of the society, my lord, this is the amended one.
Yes.
Last amendment. This is the last amendment.
This is the last amendment which has come up. Kindly see, my lord, the membership, who are the persons who are entitled to be members. The one, first, second, third. The membership of the society is open to individuals above the age of 18 years of good character, competent to contract, and are permanent employees of IOC, Haldia division. And in addition, the individuals who are not employees of IOC Haldia division but residing under the registered area of membership of the society can be admitted as nominal members. So one is, no, I am not in the nominal. I am the actual member. Well, now, keeping this open, kindly may not take the Cooperative Societies Act. I think, my lord, this is it will become absolutely clear, my lord, that there is no problem in respect of these persons.
When it came into effect?
21.
2001.
Yes.
Yes.
That's no amendment.
Before that also, if your lordship, my lord, looks into that.
Mr. Ahmed supplied one amended bylaws. What is the date of that?
Before this.
Which one is the last one?
This is the last one. This is the last one.
Which Mr. Mitra has handed up.
Yes.
But I think Mr. Ahmed said something, placed something there. It was not clarified in that.
That was the earlier amendment.
In the earlier amendment, that was there also. Let us see
But
what was there.
Ahmed placed something. Because it was not that clear with regard to nominal members. Or must be some other bylaws was placed.
No, I tell you, lordship, what was there in your lordship's mind? Kindly take section 63 of the Cooperative Society.
Yes.
Kindly take that.
Yes.
In whichever way your lordship looks at it, my lord. I am told Mr. Ahmed had shown to your lordship the one. May I find it from that bunch, my lord? The first, second, third, fourth, fifth, sixth, seventh page. That is all.
Clock 6.
My lord, kindly take this. It's a copy card. 1996.
1996. Yes.
This is 1996 amendment. New clause 6. New clause to be inserted. Any person above 18 years of age and working under IOC Haldia division may be admitted in the interest of the society as nominal member on payment of so and so. This has been amended to make it, my lord, in consonance with the.
This was the earlier one.
Yes.
That was the earlier one. Now, my lord,
Now,
this has become.
After.
Now it is.
2001, this amendment has been made of
Yes.
clause 6(1).
Yes. And here, my lord, kindly see this. They are not nominal members, they are actual members.
Don't you have the bylaws incorporating all the amendments in this way?
Is in this way.
I shall give you a lordship. One bylaw incorporating all them.
Incorporating those would be
We
better
shall
because,
do that.
which is amended, which is this piecemeal, these things.
Yes, it's bit confusing. My lord, we shall prepare this. কি করবে কি তুমি 1996 এর অ্যামেন্ডমেন্টটা তুমি গ্রিনে করো আর 2001 এর অ্যামেন্ডমেন্টটা ইন
You
রেড
can
করো।
make it in the form of a table saying
Yes.
that this was this, amended as this. This is the final one.
Appearing on behalf of the society, I shall clarify, irrespective of there being any provision with regard to nominal members, the specific provision with regard to membership of the cooperative society is not effected, because that's an independent right of a person being a permanent employee of the cooperative, the IOCL.
That Mr. Mitro's submission is that.
I will
Only on this, I want to see only these.
the further
bylaws.
clarification might have been brought by way of an amendment, but even
It is
this
unnecessary.
amendment
Statute
was
is
not
clear.
there.
According
Even-
to you, statute is clear.
Yes, statute
That's
is
what Mr. Mitro's submission is also there.
Yes, well, I would request your lordship, ঠিক আছে ছেড়ে দাও। হ্যাঁ ঠিক আছে ছেড়ে দাও। ওর তো সেটা জজ সাহেব বলছেন যে এটাকে instead of showing it that way তুমি একটা consolidate করে দাও তাহলে it will be easier. Very well, I shall do that.
We are only concerned with this clause
Yes,
only.
yes.
No other clause you can give.
No other clause, really. But my lord, kindly come to section 63 once.
Yes.
Eligibility of membership of cooperative society. I say that notwithstanding anything contained, my lord, in the bylaws, this, my lord, will be binding. My lord, kindly see this. Subject to the bylaws, of course, the bylaws is there. The following persons shall be eligible, and these are not in consonance, my lord, inconsistent with what has been shown to your lordship in the bylaws.
According to you, you become a member according to 63(2).
66,
63(2).
63, 1, 2.
2.
Yes.
An employee of the cooperative society.
Yes, an employee who is no, my lord, kindly come to first 63 1.
Yes.
63 1A, first of all.
Yes.
Subject to the bylaws, the following persons shall be eligible for membership of a cooperative society. Who are they? An individual competent to contract under section 11 of the Indian Contract Act and a permanent resident of India. Then B, any other cooperative society will not concern, state government not concerned, self-same group not concerned, any financing company. So an individual competent to contract under section 11 of the Indian Contract Act and a permanent resident of India.
And
Then
this
provided
must be
that
the expression subject to the bylaws, and bylaws states that the employees of
IOC will become a member.
So by virtue of
Absolutely.
that you become a member.
Yes, ma'am. Then, my lord, kindly come to subsection 2. An employee of the cooperative society who is eligible under subsection 1 to be member shall, on an application made by him, be admitted as a member of the cooperative society, but shall have no right to vote at an election. My lord, we are not concerned with this. Now, my lord, kindly come to section 102. I'll read section 102 with this. Not section 102. Sorry, well, it's not section 102, well, regulation 102.
Regulation.
Yeah, yes, madam. Rules. Cooperative societies rules that your lordship will please to get at the
Yes.
the back of this. 107. 107. I said that 63 read with 107 automatically makes me a member. Eligibility for membership. No person qualified to be a member of a cooperative society under the Act or the rules or the bylaws shall be excluded from membership.
It's the other way around.
It
You automatically
becomes a member.
cannot be excluded.
Absolutely, I cannot be excluded. If I qualify under 63, read with the bylaws, then 107 comes to my aid, and I automatically become a member.
You cannot be, or in other words, you cannot be excluded.
I can't be excluded. My lord, this is one, and my lord, kindly read along with this the difference between this and, my lord, subsection 3. I am not subsection 3. I do not come under subsection 3. Notwithstanding anything to the contrary contained in elsewhere in this Act, a cooperative society may admit, your lordship kindly sees, their discretion. An applicant admit any person, any association.
Mr. Mitra, I find within bracket an application.
I could not understand. I could not understand, my lord, the meaning of this.
I was thinking that there's a typographical error.
Sure.
Otherwise, it carries no meaning.
It is not typographical. It is I should say, my lord, it's a drafting error on the part of the person who has drafted this. I don't know why it is an application. May admit any person, any association, or body of persons, whether incorporated or not, as a nominal member, who shall not be entitled to any share of the. Therefore, my lord, a nominal member, a person can be admitted as a nominal member who is not entitled, who is not eligible to be a member under subsection 1.
This is over and above the ordinary members.
Over and above the ordinary. And these nominal members have got restricted rights.
They cannot have a right to vote.
Right to vote.
be voted.
Here, my lord, in this our case, there are two provisions I would like to show your lordship. One, your lordship is pleased to see just now who is eligible to be a member. The other one, my lord, is this. Kindly, my lord, take the bylaws once.
Bylaws?
Yes. The original bylaw, a copy was handed up to your lordship. Very bad printing. I don't know whether your lordship will please to read it. My lord, this is. It looks like this.
I've got a bylaws, page 48. Yes.
Yes. Kindly well come to Rule 26. Loans shall be granted to members only. Your lordship has seen that? And now, my lord, kindly take the affidavit in opposition once. The one that I was showing your lordship. My lord, kindly take these long sheets of papers. I don't know whether it is like this in your copy.
Yes, sir. Thank you.
This is Annexure R1.
Yes, those tabular charts.
Tabular charts. Kindly see, my lord. Two things here, your lordship will please to note.
These are the pay slips.
Yes, of this person.
Membership.
Yes, of these persons. The person, the petitioner.
Society membership.
Society membership number 1. Your lordship sees society membership 100, and also particulars and details, loans and balances.
Yes.
These persons have been given loans. They would not have been entitled to loans unless they had been member in terms of bylaw 26, which I just now showed to your lordship. Yes. So, my lord, they have been treated as members. They enjoyed all the benefits of a member, but the factual membership, my lord, was not granted by the directors. That is why, my lord, our grievance was there.
That is for what I am asking you, whether it is certificate. What is the according to you, automatically you become a member.
I automatically.
More that is needed. Certificate is granted. What is
certificate is to be granted, and a signature in the member register is to be done. These formalities were pending, which was completed during the tenure of the special officer, for which they were withheld from participating in the elections for such a long period of time. That formality only was completed by the special officer.
So, my lord, therefore, what was undone, what was not done, was completed by law during this period. What had been clamoring
ministerial work, according to
my lord, in my very smooth submission, yes. And that is why, my lord, they were inducted as members. My lord, they were allowed to vote. The election had taken place. Therefore, my lord, twofold submission I am making before lordship.
Take your seat, because Mr. Mitra, I think, will take some
time. I will just. My lord, twofold submission I am making. Factually, this is the position. Now, if they had any grievance with regard to my membership, they should have gone before the registrar. Kindly, my lord, see section 102. All disputes, excepting disputes with regard to election, my lord, will have to go before the registrar.
Present and past members.
Yes.
Within the expression present and past members.
The language is this section 102, disputes to be filed before the registrar. Any dispute concerning the management or business or affairs of a cooperative society other than the dispute relating to election in a cooperative society, as and when such election is conducted by the Cooperative Election Commission and disciplinary action taken by cooperative society against its paid employees regarding so and so shall be filed before the registrar for settlement. Therefore, my lord, my first submission before your lordship is this, that the dispute pertaining to membership, your lordship should not entertain this application because there is an alternative forum statutorily, my lord, given, under which, my lord, they should have proceeded. That they have not done, they are precluded from coming before your lordship. That is the first submission I am making. Second submission is this, that very well, you did not raise this dispute. Now, when the election process has started, after the notification has been issued, then, my lord, in terms of section, your lordship will please to take the, my lord, that it has to go before the election commission.
Regulation.
Yes, well, kindly see. 94, na? Section 94. Section 94.
6.
Sorry, 96.
94 is, I think,
96.
1996.
96.
Yes.
Yes.
Cooperative Election Commission. The state government shall constitute Cooperative Election Commission, so and so hereinafter referred to so and shall appoint a person to be Cooperative Election Commissioner of the Election Commission for the superintendence, direction, and control of election of all registered cooperative societies in West Bengal. The Cooperative Election Commission of the Election Commission shall hold office for a term of 3 years. Then Cooperative Election Commissioner, the Election Commissioner shall be a person who is or has been a member of the Indian Administrative Service, not below the rank of secretary or special secretary. Then the Election Commission shall hold election of all registered cooperative societies in West Bengal in due time under the provisions of so and so.
I think you can come straight away to 8.
And, my lord, kindly come to 8. Subject to the provisions of this Act, the Cooperative Election Commission shall make rules, regulations, and procedure providing for the conduct of the election, the preparation of the electoral roll, filing of fixing the date, place, and manner of election.
The preparation of the electoral.
Yes, my lord. Now, my lord, kindly, with regard to this, my lord, kindly look into article. Constitution boita kotha gelo. Your lordship, kindly, my lord, take the Constitution of India. Constitution boita kotha. Constitution নেই একটা কনস্টিটিউশন বই দাও ওকে ওটা না কনস্টিটিউশন অফ ইন্ডিয়া Article 324 sorry, your lordship sees these are by way of amendments, these have been brought in part 9 as part 9A with regard to municipalities, with regard to, my lord, panchayats, and with regard to cooperative societies. If your lordship kindly comes to part 9B, article 243ZH, cooperative societies, and your lordship will be pleased to come to clause paragraph yes, kindly come to article 243ZK. Rather confusing with regard to this ZJ, ZK, etc. 243ZK. Election of members of board. Notwithstanding anything contained in any law for the time being made by the legislature of a state, the election of a board shall be so and so. The superintendent's direction and control of the preparation of electoral rolls for and the conduct of all elections to a cooperative society shall vest in such authority or body as may be provided by the legislature of a state by law. And, my lord, this in pursuance of 243Z case sub-article 2, my lord, these provisions with regard to section 98 has been formed. Therefore, my lord, once this has been done, superintendent's direction and control and preparation of electoral rolls for and the conduct of all elections to cooperative societies has vested in the, my lord, they get the exclusive my lord, power to decide all disputes. And my lord, the decisions are there galore. If your lordship wants, I can give your lordship the reference, starting from Mohinder Singh Gill. My lord, there the courts have uniformly held that once the process of election has started and until the declaration of result, no dispute can be referred to the court of law. Everything else will have to go before the election commission. And the election commission alone will be entitled to decide this issue. Therefore, my lord, my second submission before your lordship is this, that this particular writ petition is not maintainable after the election process has started. First, it is not maintainable because the registrar has jurisdiction. Second, my lord, it is not maintainable because the election process has started. Therefore, my lord, today, when, my lord, the election has been held and these persons have been elected, my learned friends, this writ petition has become totally infructuous. These are my respectful submissions.
Sir, sir,
the election process.
Resolution 35
Entire chapter has been struck down. The entire constitutional chapter has been struck down.
Struck down?
Constitutional chapter on cooperative
Yes.
has been struck down.
Struck down.
Entire chapter, sir.
Struck down by which judgment?
By judgment of from Gujarat, if I'm not mistaken.
এটা বার করো না ওখান থেকে না বলে।
That is the decision. When?
It's a five-bench judge.
Possibly 2-3 years, at least 3 years ago.
My lord,
initial judgment was passed by Justice Bhaskar Bhattacharya's bench.
Very well. I am, since my learned friend is pointing out.
Entire this cooperative election commission goes.
No, your lordship, it is.
This act that was introduced prior to constitutional amendment. This act of 2006. But assent was given in the year 2011, if I'm not mistaken. This is an exceptional act. Though it's a state act,
No, this was part 9B.
That has not been struck down.
In 2012.
2012.
Now, it was subsequently struck down on the ground that from 50% of the state did not.
97 came into force when?
Your lordship, it has been struck down or made non-applicable only to the state cooperative societies. It is still applicable to the multi-state cooperative societies.
I would like to see the judgment before you say that it has been struck down. When you are saying constitutional provision has been struck down by the Supreme Court, I would like to see the judgment. To my knowledge, it is not there. একবার দেখো, একবার দেখি তারপরে বল।
This 2006 Act.
So far 2006 Act, I had the occasion to deal with it.
Came into force in 2010.
Yes, possibly 11. Possibly 11. This is an exceptional act, though it's a state act. Since the constitution.
2011.
Since there was a deliberation going on constitutional amendment in the parliament, therefore this is an exceptional act where the presidential assent was taken. And only
there have to say that that particular part 9B had been totally struck down. I don't think so. I don't think you are right. একবার চেক আপ করো করে তারপরে বলো। It has been directed not to be applicable in respect of certain cooperative societies. I think state cooperative societies, but subject to correction by you. একবার দেখে নাও, but I do not think that is that.
না না স্যার যেটা বলছেন ঠিকই বলছেন। So far state cooperatives are concerned.
Before we make this. That's right. That is what it is. Don't say it has been struck down.
Did not give consent. Yes. Yes.
Yeah.
Yes.
That was the observation.
It is not. It is.
So it cannot affect this operation of 96 of the
Of course not.
2006 Act.
No, 2006 has had nothing to do with the constitutional amendment, because this act was introduced prior to constitutional amendment.
Yes.
So in
96 is there, even if in
96 is there. No, just a minute. 96 is there. If correct me if I am wrong, let me summarize, my lord, that this discussion which has gone on before your lordship. 96 is still there. Part 9B is still there. The provision of the constitution with regard to the cooperative societies is still there, applicable in respect of multi-state cooperative societies, not applicable in respect of the state cooperative societies. That's what it is. If that is so, my lord, we are not concerned with it. We are not concerned with it. I was a bit taken aback when I was told
I was also surprised that
that this provision has been struck down. My lord, this is also, I am being shown, my learned junior, and rightly so. My lord, kindly take cooperative societies election commission regulations, which is, my lord, at the back of these books. Your lordship, kindly take, it is, my lord, in the schedule, I think it should be.
Regulation 3.
Regulation 35. Kindly come to
335.
Yes, 335.
Yes.
1. Any dispute relating to election of delegates in any cooperative society shall be referred to the Cooperative Election Commission within 30 days from the date of arising of such dispute. Well, kindly come to the next page now. Regulations regarding holding of election of the board of directors of any cooperative society having less than 1,000 members by the Cooperative Election Commission. As per Section 96 of the West Bengal Cooperative Societies Act 2006, the Cooperative Election Commission has been constituted, which shall conduct and supervise the entire process of election of board of directors of cooperative societies having less than 1,000 members. The procedure for holding election of delegates of cooperative societies as specified.
For delegates will apply to board of directors as well.
So, my lord, therefore, my lord, I am respectfully submitting to your lordship, whichever way, my lord, this particular writ petition is looked into, my lord, it is barred. First, because of the registrar is entitled to look into this dispute, which they did not go before the registrar at all. And, my lord, secondly, my lord, after the election process has started, my lord, this court, writ court will, my lord, lose jurisdiction until after the election process is completed. My second submission. My third submission is, my lord, this is the final submission, that, my lord, this is an attempt by one person who has got a grouse, who is seeking to, my lord, put a spanner in the works. He was trying to stop this entire election process. The grievance is not with regard to this 392%. That is my feeling. The grievance is this: don't hold the election. The election had not been held. So, my lord, the board of directors was superseded. Direction was given, hold the election. And, my lord, when the election process is on, somebody is trying to put a spanner in the works. This is a mala fide application. These are my submissions.
Yes, Mr. Sharnal. Oh, you are not in this matter. You are not in 101. No, I am not.
But so far as 4.49 is concerned, may I be allowed to file the amended cost item?
The amendment cost item.
Your Lordship, may I make submissions on behalf of the cooperative society and the special officer in 1013?
Then Mr. Sharnal, let him conclude. Apart from you, who is left in this matter?
Oh, there were some added parties. Added parties were there, possibly.
Added parties. Added parties. Who are added parties?
Your Lordship, some of the members voluntarily approached before the Honorable Court that our membership has been challenged, so we be allowed to participate in the proceedings. All have not come before your Lordship. There are few number of members, like 20 or 30 members might have approached this Honorable Court. So they form the added parties.
Make your submissions thereafter. You are adopting Mr. Mitra's submission. Yes.
Respondent number 7 to 52 are added respondents. 7 to 52 in the amended copy.
Yes.
Your Lordship, sub
4549.
1013. Your Lordship, I will be making submissions.
যেটা শুনছিলাম yes, you are which respondent numbers?
Respondent number 5 and 6, Your Lordship.
You want to place your affidavit in opposition?
Your Lordship, I will be placing my affidavit in opposition. Prior to that, Your Lordship, I will be praying Your Lordship to just have a look at the order dated 24th of February 2026. Your Lordship's order.
Yes.
Where it was informed to Your Lordship that the elections are over, the newly elected board has come in, and I had made a specific submission, which is running page 3 of the order, third last paragraph from the bottom. Mr. Sureka Learned Advocate.
All the members are necessary parties.
All the members are necessary parties. And why I say so? I have taken this point in my affidavit also, and why I am saying so. Kindly seize page 13 of their writ petition.
How many members are there?
According to them, 392 have been allegedly inducted by the special officer. So they are challenging the induction of these 392 members.
So according to you, this 392 ought to have been made parties.
Ought to have been made parties. Why? Because not only their name they are wanting their names to be excluded from the voters list, which has now become infructuous. Their prayer has now become infructuous because the voter list have been acted upon and the elections are over. But they have also challenged the membership which was granted to them. These 392 persons whose membership they are wanting to challenge. You will kindly see 7, para 7, page 13 of the writ petition. By challenging the voter list,
there is no prayer for
Lordship, by challenging the voter list, I am indirectly challenging them because they are aware of the fact that if they challenge the membership in why this writ petition, they have to go by the 102. To bypass that remedy, they have specifically chosen to challenge the voters list. If my membership is, for the sake of argument, Your Lordship, if my membership is not under challenge, by no provisions of law, I can be excluded from the membership in my names in the voter list. So they have challenged the voters list, relying on their statements at paragraph 7, page 13 of the writ petition. Petitioners state that in flagrant disregard of the said direction, as many as 392 persons were inducted as shareholder members of the society on 27th of August 2024 during the tenure of the special officer, thereby materially altering the electoral base of the society. On 15/12/2025, the ARO published a draft voters list comprising of 732 members in connection with the proposed election to the board of directors and invited claims and objections with the stipulated period. Upon scrutiny of the draft voter list, the petitioners discovered inclusion of names of 392 persons who after expiry of the elected board, rendering their inclusion in the voters list illegal contrary to statutory
according
intent.
to Mr. Ahmed, those who are the members as per the last elected board, tenure of the last elected board, they would only, their names would only find place in the voters list. Special officer cannot
and
anyone so as to alter the electoral.
And this system should continue till eternity so that they can regain the power in the board. This is the entire motive, that no new members be inducted. Their group of members
place reliance upon a decision of the coordinate bench as well.
Your Lordship, that is required to be distinguished. That is required to be distinguished. On the first occasion when Your Lordship was pleased to take up this matter, we had orally tried to distinguish that coordinate bench judgment which was passed relying on a judgment of the apex court of 2006 possibly. 2000. So that Your Lordship I will distinguish. I will try to satisfy Your Lordships on that point. But prior to that, Your Lordship, when we are arguing on the point of maintainability of the writ petition itself, so I have taken this point. No steps have been yet taken by them to add others as a necessary parties or parties in this writ petition. Mr. Ahmad on the last occasion had said that he will be placing certain judgments which he has yet not placed to satisfy your lordship's concerns that no, without them also this writ petition is maintainable. So if we get a chance to know about those judgments, we will be rebutting on that. Now, my first point which I have taken in my affidavit in opposition is page 7. Page 7 of my affidavit in opposition with regard to maintainability. This is page 7, the last paragraph. Affidavit in opposition filed by respondent number 5 and 6, your lordship.
Yes.
Your lordship, 7I, that the instant writ petition has been filed in connection with the ongoing elections of the said cooperative society. However, the petitioner has failed to implead all the members of the said cooperative society who are directly related to the ongoing elections. Therefore, the instant writ petition is liable to be dismissed for non-gender of parties. So this point I have taken, which has not been replied satisfactorily according to me, your lordship will see. Then there is the point of locus, which is at page 8L. The instant writ petition has been filed by only one member to stall the elections concerning 736 members. Therefore, the instant writ petition is again should be dismissed for non-gender of necessary parties. Then I have taken the point of alternative remedy. That is 102. That too subject to satisfying the limitation period as prescribed in 102, because they have
102, there's a limitation.
Your lordship, there is a limitation. Your lordship kindly sees 102. This is subsection 2. The first is possibly your lordship knows this falls under the definition of dispute, and this can be decided by the registrar. I may not reiterate on the same thing, your lordship. Now, if we come to subsection 2 of 102, any dispute mentioned in subsection 1 other than the dispute relating to recovery of money. So this is not a dispute relating to recovery of money, shall be filed before the registrar within 3 months from the date on which the cause of action arises. So if I again take back your lordship to
Cause of action, this is a vague term. Bundle of facts, when it arises, several facts.
That is what I
came to know.
That is what is the matter of evidence which we can prove that they were aware as on 2024. Your lordship, these are small cooperative societies, 792. Even if a pen falls from the table, your lordship, all are aware. It is not that they cannot be oblivious of the fact that since 2024, 392 people were inducted and they were not aware of. We have documents which we have been supplied, though we have not used in this affidavit because it was supplied a bit later, that people were at large were aware that these changes have taken place, and this ministerial work has fallen from your lordship was completed by the special officer before the elections. So if according to them, 27th of August 2024, if these persons were inducted, their cause of action according to us starts from the month of August 2024, or they have to show that they had no knowledge prior to that.
7th of August 2024, what happened?
These 392 persons were inducted, according to them, were inducted. According to us, their membership were regularized.
Yes. So,
if
of August, where is that document?
Your lordship, page 13, para 7, their own pleading.
Of the writ petition?
Of the writ petitions.
(27th of August).
Even if we go further, your lordship, if we go further with them, then on 15th of December 2025, the Assistant Returning Officer published a draft voter list comprising of 732 members in connection with the proposed election to the Board of Directors and invited claims and objections within the stipulated period. Upon scrutiny of the draft voters list, the petitioners discovered inclusion of names of 392 persons. So according to us, first is 27th of August 2024.
When did the tenure of the last elected board expire?
That was in the year 2021. 2021. 2020. 16 March 2022.
16 March
March
2022.
22.
All right, March
16 March 2022.
Since then, special officer.
Since then, there is the special officer. So, if the cause of action arose in August 2024, the 3 months has to be considered. That is for the arbitrator to consider whether he is satisfied with the delay, if any, caused to him according to his independent application of mind. This is, secondly, they have admitted that at least on the date of publication of the draft voter list, they were aware that these 392 persons have been inducted. Draft voter list, they were aware that these 392 persons have been inducted, but till date, we are not aware as to whether there has been a this dispute case filed by any of the persons challenging the membership of 392 persons. Now, it is not that this is the first time any litigation has been filed with regard to this cooperative society. Litigations were pending since 2022, this 4549. So, according to us, Your Lordship, they cannot take the plea that they were unaware that the board, the tenure of the board had expired. They, rather he, the single person who has come before Your Lordship by way of this application, was not aware that the special officer is running the affairs of the cooperative society. He is taking or she is taking steps, and a writ petition was also pending. So they are vigilant litigants. So they cannot say that since 2024 they were not aware of. Now, the point of locus, I have taken, Your Lordship, this alternative and mandatory remedy or the statutory remedy available to them, that is subject to limitation. Now, Your Lordship, to the clauses of the bylaws, my submissions with regard to clauses of the bylaws.
Yes. Amendment.
Not to the amendment, Your Lordship. I will take the bylaws as it was.
For
clauses 5 and 6. Clauses 5 and 6.
Yes, clause 5 and 6 relates to what?
To the who can be the members and the area of membership.
Yes, that's who are the employees of those IOCL.
Kindly cease it once.
Yes.
The area of membership of the society is limited to IOC Employees Welfare Cooperative Society, Haldia Division. Now, C6.1, membership of the society is being to individuals above the age of 18 years, of good character, competent to contract, and residing in the registered area of membership in the permanent employment.
Yes.
So 18 years, good character, competent to contract, residing in the registered area of membership in the permanent employment. Now, if these criteria are fulfilled, as have been pointed out by the added parties, persons will become the shareholder members of the cooperative society. Now, why the provisions of nominal membership has been kept, Your Lordship? If any of the criteria, specifically I would point out, if a person is not the permanent employee of a IOCL cooperative, there are institutions where several people work on casual basis, daily basis, though they may be working for a longer period of time, for 5 years, 10 years. So to facilitate facilities to them, the law was conscious about the additional provision of making nominal members, because the principles of cooperative society runs for the betterment of public at large.
Where this bylaws, where does it state about this nominal member?
No, no, একটা জায়গা ছিল।
Bylaws.
না, একটা জায়গা ছিল। At one place I had seen, your lordship, এই বলতো অর্ণব, এর ছাড়া কোথায় ছিল একটা?
In the amendment,
the right-hand side column on the second page.
It was first amended in 2006 and then
6.5
and
6.5.
there is one 96 amendment and there is one 2001 amendment. Both mentions nominal members.
Yes. New clause to be inserted.
The act provides for the nominal.
Amendment, my lord, which I pointed out to your lordship, my lord, sort of lengthy thing. There, my lord, the nominal membership has been mentioned.
Clause 5.1.
This amendment, it a Kobikar amendment.
2001.
2000. My lord, kindly take the 2001 amendment. There, my lord, in the very first provision, my lord, it is mentioned. The membership of the society is open to individuals above the age of 18 years of good character, competent to contract, and permanent employees of IOC hold their division. And in addition,
this is the addition.
Yes, this is the addition. This concept of nominal member in compliance with section 63, subsection 3. It was not the nominal membership was not there.
Yes. Yes.
Your lordship, there is one provision with regard to admission of members which restricts that a person will not have a vote to right to vote. That is at 7 subclause B. Admission of members, if your lordship sees.
Yes.
An employee of the society who is eligible to be its member shall on application made by him be admitted as a member of the society, but shall have no right to vote at an election. So this is with regard to the employee of this particular cooperative society. This cannot be inferred to be employee of the IOCL. So this restriction is with regard to the employee of that particular cooperative society, which is the subject matter of this writ petition and whose elections are subject matter of this writ petition.
Yes.
So with regard to area of membership and the membership, lordship, I have shown your lordship the bylaws. Now I will be placing the law, which has already been placed, your lordship. This is Section 64 of the Cooperative Societies Act. Your lordship has already seen section 63.
Yes.
Which says who can be the members of the cooperative society, any person individual to contract. So there is also section 64. And membership under subsection 1 of section 63 may apply to the cooperative society for admission as member thereof in the form and manner as prescribed. Every application for membership shall be disposed of by the cooperative society within a period of 45 days from the date of receipt of this application. The decision of the cooperative society on such application shall be communicated to the applicant within 15 days from the date of such decision. If no such communication is received, the application shall be deemed to have been accepted on the expiry of 60 days from the date of receipt of the application by the cooperative society. So it is immaterial whether the cooperative society is run by the special officer or a board. The law says if a person who thinks that he is eligible as per the bylaws and the section 63 has the right to approach the cooperative society. If the cooperative society chooses to decide his application, it's one way. He has the right to appeal thereafter. Even if the cooperative society chooses not to decide and sit tight over the matter, he is in action. That person will be deemed as members of the cooperative society. So even if the special officer during his or her tenure would not have considered the applications made by them, though it was not for the induction of the members, if the special officer who comes for a period of 6 months, if within that tenure, if for a moment, if we assume that, Your Lordship, there is no litigation, no dispute amongst the members of a cooperative society, which is now run by a special officer, a person comes in during that 6 months of tenure, applies to the cooperative society and says that you decide my application, either the special officer has to decide it, and if he or she chooses not to decide, then this period will come into effect and he can be deemed to be the member of the cooperative society. So the entire submissions that the special officer is not entitled to induct a member is possibly not too satisfactory according to me. Though there is a coordinate bench judgment, it is on a very different facts, considering acts of different states, which is not applicable.
Coordinate bench decision is on this act.
But not on the same facts. In the coordinate bench judgment, the election was already directed to be held by an earlier order of a coordinate bench. During the subsistence of that order, the elections were not held, but the nominated board had inducted some new members in order to change the nature of the voters list. There are also judgments of the division bench, Your Lordship. I also have the acts of the Karnataka and Kerala Act, but only difficulty which today I am facing is, Your Lordship, the submissions which I made with regard to the distinguishing that coordinate bench judgment or to satisfy Your Lordship, that page is missing from my brief today. I have the my personal note on the how to differentiate that judgment with the our act, the Karnataka Act. I have bought the acts. If Your Lordship pleases, act on one act.
Yes, you can make your other submissions, then
Your Lordship, with regard to maintainability, Your Lordship, it is first is non-joinder, the second is locus, the third is alternative and specific remedy, that too subject to limitation. Thereafter, they had the knowledge of cause of action. So this is a belated and a delayed. There is history of litigation. I say this is an attempt of forum shopping. They had earlier not been able to get any orders. So they have put in someone from amongst their group to challenge the entire process. It has, the writ petition has now become infructuous to the effect that the elections have been held. If they want to deliberate anything on our on the membership of the persons who have been inducted, we are ready to answer on behalf of the cooperative society. And the clause 5 and 6 of the bylaws I have already placed. I have also shown Your Lordship the section 64, which also provides that even if a person decision is not taken on the application of the cooperative society, by the cooperative society, that person can be deemed as a member of the cooperative society. And this aspect was also not dealt in the coordinate bench judgment, neither by the apex court, not in the coordinate bench judgment, and the Kerala and the Karnataka High Court also does not have these provisions of deemed membership. The term special officer, which has been relied on by the apex court, has an entirely different.
What are the functions of the special officer? What functions?
Your Lordship, section 36. Section 36 of our act. Your Lordship, subsection 4, section 36.
Yes.
Your Lordship, we can also see subsection 2. The special officer appointed to manage the affairs of the such cooperative societies shall arrange for conduct of elections within the period specified in subsection 1 and hand over the management to the newly elected board. So one most important part is to arrange for conduct of elections and hand over the management to the newly elected board. Now, in the meantime, section
manage. So what are the functions
now
special officer can do?
Your Lordship, subsection 4B. Subsection 4B, subject to the control and direction of the registrar, and notwithstanding the preferring of an appeal under section 147, which was not preferred, the special officer shall exercise all the power and perform all the duties which may under this act or the rules or the bylaws be exercised or performed by the board or any officer of the cooperative society.
Yes, what is the functions of the board? Because I think the statute which was considered by the Honorable Apex Court had similar wordings.
Your Lordship, this is where I this is where I join issue, Your Lordship. In the Apex Court judgment, which had considered the Kerala Cooperative Society and the Karnataka Cooperative Society, one was in case if the society goes under liquidation, at that point of time, the person who was appointed was defined as special officer. A person, a society when goes under liquidation. Your Lordship, I have that.
Please show me the functions of the powers of the board first. What are the functions of the board?
Rule 52 দেখান আমি ওইটা
Rule 52 is the power. Rule 52 is the power. Rule 52 is the duty. Clause G of Rule 53 may be of relevance in our matter.
To maintain register of members up to date. So that is one of the powers of the duties of the board.
Duties of the board.
And special officer also has the
same powers, all powers and duties of the board which may be in the act and the bylaws.
If that power is vested, special officer also has that power under section 36(4). B. All the powers and perform all the duties. So 53G. Admission of members, power vests upon whom?
The board, Your Lordship, if there is no special officer, the admission of membership by the
board is there.
Your Lordship 64(3), then it is the society. Your Lordship kindly sees the wording of 64.
Yes.
Any person eligible for membership under subsection 1 of section 63 may apply to the cooperative society for admission as member. So the cooperative societies are managed by the elected board if there is no special officer.
Yes.
If there is special officer by special officer, if there is administrator by administrator.
So it's the power of the board.
It's the power of the board.
Full control over the administration and the business and some exercise also involves as may be necessary for the purpose of carrying. Yes. 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 Yes, Mr. Sureka, how much time it will take?
Your Lordship, I will just try to satisfy Your Lordship how that coordinate bench judgment was not violated. Rather, 15 to 20 minutes, Your Lordship, I will be taking.
Yes. When can you come?
Your Lordship, any day, anytime next week, next week, Your Lordship. Then I will be getting a week further to. I will be getting a week further to come back with good instructions.
I think because some motions are there, that has to be given some. So I'm keeping it 28.
28.
Because 14th is holiday.
28th of April.
It's Mittola. Amended constantly in which
4549 WPA number 4549 of 2020.
Have you supplied copies of the application?
Not be contacted.
Don't believe me. Sorry.
When at the final hearing, they will come up and say we have not got it.
Well, don't go with me.
Yes.
For the next matter, Mr. Bhattacharya appearing, that matter may be taken up after election. After 28.
Last occasion, we had pointed out this, that Mr. Bhattacharya will be busy for the elections, and we had faced we faced a strong objection from my London friend.
না objection নয় এ আবার কি কথা কথা না বলে বলবো কি করে
190, Mr. Bhattacharya is for the petitioner.
Yes. Yes,
190.
Deep here. 90th of
Other matters? No. Which? The other matters you want adjournment. In which matter? 191. But who is for the respondent? I do not know whether they have any objection. Mr. Oh, is it that appointment matter?
The last appointment, the point of mentality was
Appointment, I think Mr. Banerjee Bandyopadhyay was strongly.
I had also made my submission.
Rekha is also there, but Mr. Bandyopadhyay
Your Lordship, yes.
opposing. Let it appear, otherwise.
Well, one.
The holiday.
Coming week is a holiday, Mr. Sharnar. He'll be coming to court in the coming week. After
10th. I will come back on 16th.
You come back on 16th. So 13th you will not be coming.
And 13th we are arranging for.
Not 190, 12th of May.